Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Satyama Kama Maharaj, Senator, the Honorable Dominic Smith, Senator Dr. Marlene Atz, and Senator Michael S.V. Labastide, SC, all of whom are out of the country. Senators, Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Kala Kangulu, ORTT. By Her Excellency Christine Kala Kangulu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Mr. John Heath, whereas Senator Dr. Marlene Atz is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Christine Kala Kangulu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, John Heath, SC, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence of Senator Dr. Marlene Atz from Trinidad and Tobago, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 12th day of November 2025. By Her Excellency Christine Carla Kangulu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Dr. Deborah McPhee, whereas Senator Michael Simon Victor de Labastide SC is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangulu, President as aforesaid, in exercise of the power vested in me by Section 44, 1A and Section 44, 4C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Deborah McPhee, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence of Senator Michael Simon Victor de Labastide SC from Trinidad and Tobago, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 13th day of November 2025. Honorable Senators, Senators are required to take the oath of office. Could we all stand?
I, John Heath, SC, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Deborah McPhee, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Put your mobile on silent. Honorable Senators, I'm awaiting 2 further instruments from Her Excellency. As soon as those instruments arrive, we shall in fact take the necessary steps to have the senators in question take their oath of office. So I crave your indulgence at the appropriate time.
Papers.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the statement of recovery and expenses of the Ministry of Energy and Energy Industries for the year ended December 31st, 2024. The annual audited financial statements of the Export-Import Bank of Trinidad and Tobago for year ended December 31st, 2024. The annual administrative report of the Ministry of Finance for the fiscal year 2021-2022, and the annual administrative report of the National Investment Fund Holding Company Limited for the year ended December 31st, 2024.
Minister of Tertiary Education and Skills Training.
Mr. President, I have the honor to lay on the table the following papers as listed in the order paper in my name: the annual administrative report of the National Trade Agency for the year 2022 to 2023, and the annual administrative report of the Accreditation Council of Trinidad and Tobago for the fiscal year 2023 to 2024.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in my name: the annual report of the Police Service Commission for the year 2024, and the annual report of the Teaching Service Commission for the year 2024.
Leader of Government Business.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in the names of the Minister of Trade, Investment and Tourism and the Minister of Homeland Security. Firstly, the annual administrative report of the National Flour Mills Limited for the year ended December 31st, 2024, and the annual administrative reports of the Ministry of National Security for the fiscal years 2018 to 19, 2019 to 2020, 2020 to 2021, 2021 to 2022, and 2022 to 2023.
Thank you. Honorable Senators, I'd like to revert to the matter I brought to your attention earlier. By Her Excellency Christine Carla Kangulu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces, to Mr. Ashworth Jack. Whereas Senator the Honorable Satyakama Maharaj is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangulu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Ashworth Jack, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Satya Kama Maharaj, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 14th day of November 2025. By Her Excellency Christine Carla Kangulu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Dr. Kirk Megu, whereas Senator the Honorable Dominic Smith is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kanglu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Kirk Megu, to be a member of the Senate temporarily with effect from the 14th November 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Dominic Smith, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 14th day of November 2025. Honorable Senators, 2 senators are required to take the oath. Can we all stand?
Excuse me, sorry. I, Ashwa Jack, having been appointed a member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, will conscientiously, impartially discharge the responsibility of the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Kirk Megu, having been appointed a member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Questions on notice, questions for oral answer.
Mr. President, I'm very happy to announce that the government is pleased and ready to answer all of the questions appearing on the order paper today, to wit, questions numbers 10, 12, 13, 14, 24, 25, 27, 28, and 29. And I still hope that we can have an early date today.
Senator Melanie Roberts-Radgman.
Question number 10 to the Minister of Homeland Security.
The Honorable Minister of Homeland Security.
Good morning, Mr. President, and thanks for having me in this honorable house to answer these questions. Based on the information received from the Commissioner of Police, the Trinidad and Tobago Police Service, under the oversight of the Ministry of Homeland Security, has activated a multi-tiered approach framework to ensure accountability, investigative integrity, surveillance, compliance, and comprehensive review of police actions. In this regard, the following measures are currently in effect. Independent investigations and oversight by the Police Complaints Authority, clear use of the use of force policy, discipline consequences, data reporting and statistics, public communication and transparency, instructions given to investigators with timeline to comply. Investigations include immediate scene management, independent oversight, separation of the officers involved, timely and transparent reporting, use of forensic technical tools, communication with the public, and training of investigators. Mr. President, parallel administrative and criminal procedures. Administrative review, whether the officers followed TTPS policy. Criminal investigations, whether shooting breached the law, whether the shooting breached the law, and running them in parallel, presence, delay, and ensuring firmness. Surveillance, Mr. President. Use of distributions of body-worn cameras. Policy, departmental order, mandate use. Oversight, again, by the Police Complaints Authority. Standard for evidence, data, and privacy. Public parliamentary oversight and reporting. And finally, Mr. President, the review of police actions. Investigations by the PCA, use of force policies and legal frameworks, policy mandate to wear body-worn cameras, National Security Council and regulatory revisit or review, and public transparency and reporting. That answers the question, Mr. President.
Thank you, Mr. President. Through you, I have 3 supplementals, please. The first supplemental to the Minister, you indicated that information on the status of investigations are being communicated to the public. Can the Minister indicate what method is being used, and how are these investigations being reported? Thank you.
The Honourable Minister of Homeland Security.
Mr. President, as it relates to the giving information to members of the public, the police service through its information technology department issues information to members of the public via its website.
Senator Radgman.
Mr. President, my second supplemental, the Minister indicated that there are timelines for completion and submission of reports. May I please ask the Minister how these timelines are being enforced and how are investigative officers being supported to ensure that these timelines are actually being met?
Mr. President.
The Honourable Homeland Security Minister.
Mr. President, the timeline is an instruction given by the senior police officer to the investigators of any offense that is committed. A time frame is given, and if additional time is required, it is then applied for.
Senator.
President, the Minister also indicated that there is a body cam policy and a use of force policy that's being enforced presently. Can the Minister indicate whether these policies are new, and also if he can submit a copy of these policies for review? Thank you.
The Honourable Minister of Homeland Security.
Mr. President, these policies are not new. The use of force policy has been engaging the attention of law enforcement, if I recall, since 2007 or 8. And also, the body-worn cameras, also, this policy is not new. Thank you. And to answer the question, you asked another question relating to the copy. I will try to have it brought to this Honourable House as soon as possible.
Senator Faris Al-Rawi.
President, to the Honourable Minister of Homeland Security, question 12.
The Honourable Minister of Homeland Security.
Mr. President, with respect to the question, based on information received from the Commissioner of Police, the following information is relevant. As of September 2025, virtual hearings are actually conducted at 13 police stations around Trinidad and Tobago. And virtual hearings conducted at these designated police stations accommodate the full spectrum of criminal matters, ranging from summary offenses such as simple assaults and public order breaches to indictable offenses, including serious crime such as murders. And 3, with respect to the data required, a comprehensive cross-reference exercise between the virtual courts and the attendance at to maintain the judiciary and the station level lodged. Mr. President, we haven't yet got that information with respect to the amount of persons who would have attended these hearings over the time frame. Also, with respect to the data concerning the domestic violence matter, hearing in virtual courts. Mr. President, the identification of police stations between 2000 and 2025 is not immediately available. Accurate reporting requires a coordinated review of the judicial case file alongside TTPS station level recording to ensure completeness and consistency. Given the value and sensitivity of such matters, the information is not readily available. A detailed and verified response will be provided in due course. Once necessary tabulations and cross-checks have been completed.
Yeah, Senator Faris, Al-Rawi.
Thank you, Mr. President. Thank the Honourable Minister for the answers. Supplemental question number 1. In relation to the answer provided by the Honourable Minister as to item 2 of the question, I ask, what is the total number of police stations versus the 13 now given in answer where virtual hearings are conducted as designated centres?
The Honourable Minister of Homeland Security.
Mr. President, the 13 I mentioned are in fact used as virtual court up to this date.
The Honourable Senator Faris, Al-Rawi.
Regrettably, the Honourable Minister hasn't answered the question. I'm asking for 13 out of how many, if I put it quite simply.
Okay. Mr. President, 13 out of 77.
Thank you.
Okay.
Thank you, Honourable Minister. Thank you, Mr. President. With respect to the answer provided to item 3, could the Honourable Minister indicate when the response to this exercise of audit, if I put it that way, will be completed, bearing in mind that 7 months have passed since the answering of this question, since this question was posed? So insofar as 7 months has passed,
No.
could you answer?
Just ask the question.
I did.
Please. The Honourable Minister of Homeland Security.
Mr. President, for the accuracy of this information, we depend on the organizations to present it. So we want accuracy before we bring it before this Honourable House.
Senator Faris, Al-Rawi.
Mr. President, with respect to the answer provided to part 4 of the question, I ask, when will this data be provided insofar as 7 months have passed? And just for clarification, the Honourable Minister mentioned a period of 2000 to 2025. The question was 2020 to 2025.
The Honourable Minister of Homeland Security.
Yeah. Can I, Mr. President, put the answer to the Honourable Senator in writing?
You okay? Okay. Senator Faris, Al-Rawi.
Mr. President, to the Honourable Minister of Homeland Security, question 13.
The Honourable Minister of Homeland Security.
Mr. President, as it relates to the police stations, as I will repeat, 77 police stations in Trinidad and Tobago are presently occupied by police officers. The locations of the police stations being used as virtual courts: Arima, Besson Street, Chagonas, Couva, Learo, Point Fortin, Princess Town, Rio Claro, San Fernando, Sandy Grande, Scarborough Tobago, Siparia, and Tunapuna.
Yes. Okay. Senator Faris Al-Rawi.
Question 14 to the Honourable Minister of Homeland Security.
The Honourable Minister of Homeland Security.
Mr. President, relative to the question by the Honourable Senator, a comprehensive review is being undertaken relative to the parties with respect to the situation that exists with the virtual hearing in order to come to a compromise as to how we go forward.
Thank the Honourable Minister for the response. In light of the response, I ask the Minister, on what basis then did the Minister speak, as reported in the newspapers, that there was a certain policy to cancel virtual hearings at police stations?
I think...
the Honourable Minister of Homeland Security.
Mr. President, I think that the Honourable Senator misunderstood what I said.
As usual.
Give me the opportunity to correct the goodly senator and the reporter, as usual. Mr. President, what I said was that the courts was occupying areas of the police station, and as a result of that, the police, different units, would have lost their ability to continue investigations, to do identification parade, and it can go on and on. That is what this statement was about. Thank you.
With respect to the answer given to the supplemental question, is the Honourable Minister therefore stating that he was misquoted by the media?
I would have already addressed this from my last conversation, Mr. President. Thank you.
Any further questions?
Yes, please.
Yes.
Thank you for the supplemental answer. In light of the supplemental answer, is the Honourable Minister therefore willing to retract the statement that I have misquoted you insofar as my question was posed on the publications in the public domain by the media?
Mr. President, and Order 27.9, that does not arise in relation to the last answer.
Okay, sustain. Any further supplemental? Okay, right, thank you. Let's continue. I invite Senator Melanie Roberts-Radgman at this time.
Thank you, Mr. President. Question number 24 to the Attorney General, please.
The Honourable Attorney General.
Mr. President, the question is broken down into three parts. Parts 1 and 2 are, in my respectful view, tautologous. The answer, nevertheless, is as follows. The process leading to the settlement of the legislative agenda has lasted several months. The agenda is in its final stages of development. It is anticipated that the agenda will be read in the House of Representatives within the next 3 weeks.
Senator Melanie Roberts-Radgman.
Thank you again, Mr. President. Question number 25 to the Minister of Defense.
The Honorable Minister of Defense.
Mr. President, I'm instructed that 14 drownings occurred during the period identified in the question. 5 of them at Mearo, 6 at Toho. All of them occurred outside of the patrol hours and outside of the patrol areas. There was 1 in Los Zero, which occurred beyond the patrol area, and 2 in Maracas. We have not had such a spike either before or since the period identified in the question, and there's therefore, I am instructed, no need for any change to the existing signage and arrangements.
Okay. Senator Melanie Roberts-Radgman.
Thank you again, Mr. President. Question number 27 to the Minister of Homeland Security.
Question, the Minister of Homeland Security.
Mr. President, relative to information received from the Commissioner of Police, the total number of criminal offenses reported across all divisions are as follows: 928 for May 2025, 919 for June 2025, 1,056 for July 2025, 842 for August 2025, and 749 for September 2025. The second part of the question, Mr. President, the total number of criminal offenses detected across the divisions are as follows. For May 2025, 257. For June 2025, 315. For July 2025, 355. And August 2025, 305. And as of September 2025, 272.
President, there are 2 other bits to the question, 2 other parts.
You have 2 other parts.
All right. As it relates to part 3 of the question,
Right.
in relation to the publication of statistics referred, the Trinidad and Tobago Police Service, through its Information Technology Department, is currently reviewing the process of publishing the data on its official website. Once the verification and approval is granted, the process is completed, the information will be made available, publicly available, on the TTPS website. The figures provided for parts 1 and 2 of the questions were published by the TTPS website through its Information Technology Department on October 24th, 2025.
John.
One supplemental for the Honorable Minister, please. Can the Minister indicate indicate the reason for the absence of the data for the periods indicated in the question. Why was the data not published prior to October 2025?
The Honorable Minister.
Mr. President, in the age of technology and wanting to give members of the public the correct information, there were some issues. It has since been resolved. The system is back up and running. So the facts is what we'll give to members of the public.
No further. All right. Senator Melanie Roberts-Radgman.
Thank you, Mr. President. Question number 28 to the Minister of Public Utilities.
The Honorable Minister of Public Utilities.
Thank you, Mr. President. Mr. President, before I begin my response, let me thank you for the opportunity to be in this august and honorable House to answer the question as posed by Senator Melanie Roberts-Radgman. Mr. President, recently in Tobago, the raw water supply was severely impacted, resulting in an unsatisfactory delivery of supply to customers across the island. All supply zones in Tobago, with the exception of the Bloody Bay supply zone, were impacted, with customers in the Coland supply zone and Southwest Tobago especially affected. Disruptions arose due to the following factors. One, the period in question experienced lower than average rainfall with a consequential reduce in flows at the surface sources. The Trinidad and Tobago Meteorological Services reported that rainfall experienced in September and October was 43% and 60% respectively of the LTA, which is the long-term average, and it was noted that the Coland and Highlands road water treatment plants have been the most affected. Two, a series of mechanical challenges and ruptures of key transmission and distribution pipelines further exacerbated the above situation during the month of September. The mechanical challenges observed during the period in question were influenced by the age and condition of existing infrastructure, compounded by resource constraints that have limited the scope of maintenance activities and the procurement installation of standby and spare units. Also, lack of funding and neglect of proper preventative maintenance over the last 10 years would have exacerbated these mechanical issues. Mr. President, the authority now continues to perform regular maintenance interventions to sustain operations and ensure service continuity. Many of the reference facilities, Mr. President, have been in continuous operation for over 2 decades, and the aging condition of mechanical and electrical components has naturally increased their susceptibilities, Mr. Speaker, to failure. While ongoing maintenance helps extend the operational life, a number of these sites have been earmarked for comprehensive upgrades and replacement, for which funding is currently being sought under capital improvement initiatives. In short, Mr. Speaker, we will fix it. The repeated pipeline ruptures are primarily associated with the corrosive nature of the soil, which accelerates the degradation of the metallic couplings and fittings along the 16-inch transmission main. This environmental factor, Mr. President, presents an ongoing challenge despite the authority's active maintenance response. To mitigate future occurrences, the authority is exploring enhanced protection measures for underground infrastructure, including corrosive-resistant materials, protective coatings, and cathodic protection system to improve long-term durability and reliability to the network. The following short-term, medium, and long-term initiatives were implemented to mitigate against the challenges which were experienced across Tobago. 1. Scheduled transportation of water into the Coland system via the 16-inch transmission pipeline, which was developed for this purpose for the following wells: A, Bacalet number 3, B, Bacalet number 5, C, Calder Hall well, and D, Pentecostal Light and Life well. In times of supply shortfall experience, Mr. President, of the Coland supply zone, this supply is introduced directly into Crown Point and environs, bringing rapid relief to this area. This initiative remains ongoing to continuously address intermittent challenges in supply delivery. 2, augmented water trucking. Contracted water trucks presently provide service in fulfilling regional requests for truck-borne water in the event of system shortfalls, and incomplete schedules. An additional WASA-owned water truck has been added to the fleet of contracted water trucks providing truck-borne water on request. In addition, the authority is in the process of engaging a pool of additional water trucks on an as and when basis to augment any or all additional need at this time and to cover any further challenges. 3, aggressive leak repair program. The Tobago region has embarked on an intensive leak repair program with a view to reducing visible leaks, thereby decreasing the associated wastage and allowing more water to be made available to our customers. 4, bulk metering. Tobago has commenced. Thank you, Mr. President.
I'll ask Senator Melanie if she has any supplementary.
Thank you, Mr. President, and thank you, Minister, for your comprehensive answer. It's truly appreciated by the people of Tobago. One very quick supplemental, please, Mr. President. You indicated that there will be one additional, and you're in the process of maybe procuring on an as-needed basis additional water trucks to augment supply. Can you indicate how many water trucks are currently in rotation right now in Tobago?
The Honourable Minister.
Mr. President, I will provide that response in writing, Mr. President.
Okay. Senator Melanie Roberts-Radgman.
Thank you, Mr. President. Question number 29 to the Minister of Public Utilities.
To the Honourable Minister of Public Utilities.
Thank you, Mr. President. Mr. President, given my comprehensive response just now that took me over the time, I'll be a little more concise this time. Mr. President, to proactively address the risk of continued low rainfall and ensure a reliable supply in Southwest Tobago during the 2026 dry season, the Water and Sewage Authority has implemented and expanded several mitigation strategies. 1, water importation. 2, water trucking. 3, leak repair program. 4, operational readiness. 5, facility optimization. And 6, dredging of rivers. Thank you, Mr. President.
Any supplemental?
Supplementals, please,
Okay,
Mr. President.
All right.
Public business, government business, bill second reading.
The Honourable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Mr. Speaker, the bill before this Senate today represents a continuation of the government's efforts to not only build a justice system that is efficient and responsive, but also to remedy deficiencies in the operationalization of the law. The government introduced the Administration of Justice Indictable Proceedings Act, commonly known as a JIPA, in 2011. That landmark legislation represented a decisive departure from the archaic system of preliminary inquiries which had long strangled the justice system, and in that law we rejected delay as an acceptable feature of justice. It's been 14 years since 2011, and a JIPA continues to evolve. And as with all systems grounded in reform, continuous review is essential. Since 2011, in the 14 years, the legislation has undergone a series of 9 subsequent amendments. We are informed by statistics presented by the judiciary that AJIPA has, however, been successful in expediting pre-trial hearings. But stakeholders have highlighted legislative deficiencies, and that is what brings us here today. We seek to remedy 2 urgent matters involving the issuance of search warrants and the grant of bail this morning. Mr. President, the bill before us was debated and passed in the other place on October the 10th of 2025. In that place, the debate underscored the balance between investigative efficiency and the preservation of constitutional safeguards. At its core, the original amendment addressed a specific gap in the administration of criminal justice. That is, the limited access to judicial officers who were authorized to issue search warrants in urgent and time-sensitive investigations. AJIPA had removed the jurisdiction of justices of the peace to grant search warrants in respect of indictable matters. The police service has brought to light the realities since 2023 when that amendment was made. They said that in the absence of JPs being empowered to issue search warrants in indictable matters, they face practical constraints. Investigations that hinge upon the timely securing of evidence, and that may be digital, physical, or documentary, have at times been hampered by the unavailability of masters or registrars, particularly after hours, on weekends, and sometimes on holidays. Indeed, when the jurisdiction was removed in 2023, we have been told that there were 3 masters. Of course, there were registrars. And the jurisdiction was removed not only from JPs, but from magistrates in respect of indictable matters. Everything was pushed up to the level of masters. This bill seeks to address that problem squarely without diminishing judicial oversight. It aims to restore a balanced framework, re-establishing concurrent jurisdiction among magistrates, magistracy registrars, clerks of the court, and justices of the peace to issue search warrants under AJIPA, whilst ensuring that the law keeps pace with the realities of policing and the rights of citizens. Now, I want to turn to the previous power of justices of the peace to issue search warrants for indictable matters. And there are a couple of points which I wish to make at the outset. First, this is not a novel matter. As a matter of fact, the offices of justices of the peace in practically every territory that we have examined, Jamaica, Barbados, St. Vincent and the Grenadines, St. Lucia, Guyana, Canada, the United Kingdom, New Zealand, and Australia, in all of those jurisdictions, justices of the peace have the power to issue search warrants in respect of indictable matters. So it's not novel. And that, of course, that power was present in Trinidad and Tobago up to 2023, when by way of an amendment to the JIPA, it was removed. Second, when the jurisdiction was removed in 2023, no real rationale was provided for it. I've checked the Hansard, and if my colleagues can point me to something in the Hansard that speaks to a matter which is different from what I've just represented, I'd be happy to correct the record. But no real justification was presented for removing it. And thirdly, the realities on the ground, as I've said, suggest that the amendments were either, and I'm using careful language here, misinformed because there was no rationale, and that's in respect of search warrants, or invalid, unconstitutional. And I say that in respect of the decision 3 weeks ago, that they were exactly that. There's a High Court decision which says that as far as bail is concerned, it was the 2023 amendment was wrong. So the general point is that the amendment that was made in 2023 was either misinformed or illegal, contrary to law. That's a fact. Now, I want to turn to look at the legal foundation and history of the powers which are granted to justices of the peace. So I made the point that this officer in practically every territory does exactly what we propose of him today. Every one of those territories that I've set out before, those are territories with a strong Commonwealth, common law jurisdiction. So let's look at the legal foundation and history of the powers granted to GPs. Historically, GPs had wide-ranging powers in indictable matters. So under the repealed Indictable Offences Preliminary Inquiries Act, Chapter 1201, particularly in time-sensitive situations requiring urgent judicial intervention outside of regular hours, GPs were very useful. Under the former act, they possess concurrent jurisdiction with magistrates. Their statutory duties included the express power to issue summonses, warrants, and other processes of the court, to grant bail, to which we'll come in a little while. That's the subject of the illegality point. It's now covered by authority, so there's no argument on it. So they had a power to grant bail, to fix the amount, to take recognizances, to bind over parties, witnesses, to administer oaths, all relative to indictable offenses. Specifically, as it relates to search warrants, Mr. President, GPs were empowered to issue search warrants related to indictable offenses under Section 5 of that Act. While the proclamation of a JIPA and the amendment in 2023 subsequently purported to remove those key functions concerning indictable matters, it is important to note that even the 2023 amendment, under that amendment, JPs were allowed to retain the statutory power to issue warrants for summary matters. This power is explicitly provided for under Section 37 of the Summary Offences Act. It was the removal of the jurisdiction related to indictable offenses that created the operational constraints for the TTPS. So they retained the power to issue warrants in respect of summary offenses. It was the power to issue warrants in respect of indictable offenses that was taken away in the 2023 legislation. And I've said, I've searched the Hansard and seen absolutely, it's a remarkable thing that you ask the Parliament to do something without saying, well, you know, I thought about it last night and I think I don't like JPs, or, I mean, there must be something. I saw nothing, not even that I don't like JPs. There was nothing. As far as I could see, if you could point me to something, I'll happily correct the record. Now, there is guidance on the issue of search warrants by Mr. Justice Budu Singh J, as he then was. Of course, he has now been elevated. He's a Chief Justice. Now, he made clear in the case of Central Broadcasting Services versus the Commissioner of Police that the power to issue search warrants must be exercised with judicial diligence and constitutional awareness. Now, before my learned friends on the other side jump up to say, well, okay, judicial diligence, that means masters. That's not so. At common law, justices of the peace had exactly this power, and judicial there refers to how they should act. So it's judicial diligence, not a judicial officer. Judicial diligence, constitutional awareness. That's what Justice Budu Singh, as he then was, said in Central Broadcasting. And then he went on to say, and I quote, "The law goes on to show how important the application process for a warrant is, and the need for careful consideration and scrutiny of the process that is used." So, Mr. President, it is not merely about enabling police efficiency, although I say that the police have brought us here today. It is about balancing that need, what the police wish, and the protection of citizens' rights. And I say that will be borne out when I get to the point of bail. In Central Broadcasting, the judge drew on a deep well of legal tradition and jurisprudence. He cited first the report of the Law Reform Commission of Ireland, which reviewed the origins of search warrants, dating them back to Roman law and English common law. Of particular note is the case of Entick versus Carrington, 1765. Now that's a very old authority in which Lord Camden, then Chief Justice, famously affirmed that, and I quote, "The common law holds the property of every man so sacred that no man can set foot upon his neighbor's clothes." This is CLOSC, and it is Old English, "without his leave. If he will tread upon his neighbor's ground, he must justify it by law." Justice Budu Singh made it clear that search warrants had to be, and it had to satisfy three criteria. They had to be specific, they had to be justified, and they had to be issued with great caution. Those were the three things that he said were absolutely necessary. And those are principles that remain at the heart of modern search warrant jurisdiction. Those principles, Mr. President, are not academic. They are constitutional safeguards. Any person, when approached to issue a warrant, must act not merely as a facilitator, but as an officer acting judiciously, performing a constitutional function. To further underscore the gravity of this responsibility, Justice Budu Singh, as he then was, referenced Stone's Justice Manual 2018, which outlines strict procedural requirements which he said should be followed when applying for a search warrant. The detailed procedure demonstrates the rigorous standards that judicial officers are expected to apply when authorizing search warrants. Mr. President, I commend that case and the guidelines set out therein to the police service, to justices of the peace, and to all of those who, assuming the legislation is passed here today, will be charged with applying for and granting search warrants. Now, I turn to speak to the amendments as they relate to the question of bail. The bill seeks, in its amended form, and the amendments have in fact been circulated by the leader of government business, to bring clarity to the role of JPs in granting bail for indictable offenses, because, and I pause here to say, Mr. President, that when the jurisdiction in respect of search warrants was removed in 2023, so too was the jurisdiction in respect of bail. Now, I was advised that the policy under a JIPA was to limit bail in respect of indictable matters to, in the same way that the limitations were placed in respect to the issuance of search warrants. That is to masters and registrars only. And if I could just digress for a second to say that when the amending law was passed in 2023, it is a matter of record that there were just 3, perhaps 4 masters in the entire country who were employed. Of course, they would work alongside registrars and so on, to deal with the question of bail search warrants. So I understand the frustration of the police service, certainly in 2023. Now, it would be wrong of me to say that a significant number of masters have not been employed since. They have. But the police service say that the situation has improved, but that they prefer the mass of assistance that they get from having GPs perform this function. Now, before the amendment which we proposed this morning, before this amendment could have been conceived of, the High Court, after the debate in the other place, the House of Representatives, ruled that it was unconstitutional to remove the jurisdiction. Well, they said that the precise ruling was that Parliament could not have intended to remove the jurisdiction to grant bail in circumstances where no adequate alternatives had been provided for. And I intend to go through the case. The case is Joel Alexander versus the Attorney General of Trinidad and Tobago, and it was decided on the 15th of October. I think the debate downstairs took place on the 10th of October. So we will focus on search warrants in the house below, which was a product of the police service asking us to do some work in respect of search warrants. In the intervening period of time between when the bill was passed in the lower house and when it's been brought here, the High Court has pronounced on a related question, and that is bail. They've said that insofar as that attempt to take away bail in respect of indictable matters is concerned, whatever reason, unconstitutional, struck down, and so on. Now, I propose to go through the decision of the court in that case It's a decision of Madam Justice Gobin. What she held was a couple of things. She held first that Section 10 of the Act did not have the effect of removing the jurisdiction of JPs to grant station bail to persons against whom charges are laid indictably. 2, the policy which removed the power of JPs to grant bail in such circumstances, null and void, illegal. The power of justices to grant station bail is restored, and she declared that, and this is important, the failure of the state, the state had failed in its duty to put systems and/or mechanisms in place to ensure that effective access to bail outside of court hours could be obtained by the claimant in that case. So, Mr. President, in order to bring consistency to the legislation, to take into account what Madam Justice Gobin said, with which we agree on this side, we've circulated the amendments which are before this House to explicitly provide that JPs do have jurisdiction to grant bail for indictable offenses. We are codifying the JP's restored jurisdiction to grant bail in these matters. So we're not relying on the decision of the court. We are codifying the decision of the court. Mr. President, at paragraph, I'd just like to cite one or two paragraphs from Her Ladyship's ruling. She ruled that the long-standing authority vested in GPs to grant station bail, as I said before, remained intact under our existing legal framework. And she traced that to the GP's common law power to grant station bail for indictable offenses. And then she looked at Section 10 of the AJIPA, and she says it does not expressly or by necessary implication repeal the power of JPs to grant bail at common law, and she turned to a principle of statutory interpretation. She said that courts presume that parliaments do not intend an implied repeal or repeal of a common law rule. And that paragraphs 31 and 32 of her judgment, she distinguished the jurisdiction of JPs and magistrates, rejecting the argument that the legislation which removes a magistrate's power automatically extends by implication to JPs. She holds that JPs are a vital safeguard on individual liberty and a manifestation of the constitutional presumption of innocence. Mr. President, I want to turn briefly to another and the last of the proposed amendments which are here this morning. In the AG versus Achille Charles, the court held that in respect of bail, that was a matter that could not, it fell within the purview of the judiciary. We had done several things in respect of bail in the past, some of which were done, and I have to see, when I was here before, in the sense that
was such a brilliant thing.
The country faced difficult circumstances. People were being kidnapped every Monday morning, and they were being released on bail and reoffended. So it was, that's what our intelligence suggested. So we passed a blanket statute to deny bail. And we put a sunset clause in because we realized that that was draconian. It didn't apply to all offenses. It applied to kidnapping and a few other offenses. Now, I can say at the time that I had concerns. I can say now that I had some concerns about the constitutional propriety of that, even though, and that is the reason why I put in a sunset clause. I said there's a crisis, not sure which way we should go, and to be fair, I'm sure that the House as a whole, the government and the opposition agreed on it. So we did not have a constitutional majority. And the leader of the opposition at the time joined with government and we enacted this statute.
Big man knows this, big man.
Of course, my fears were borne out when the legislation was declared to be unconstitutional. We have come across a form of words which we think makes it, we put a burden on the accused that he must show exceptional circumstances and such other things. Sufficient cause, exceptional circumstances to grant bail for certain serious offenses, and that is murder and other violent offenses. And in the amendment before us today, because we're dealing with bail, yes, we are conscious of the fact of Justice Gobin's concerns. But if you read the decision of Justice Gobin, she explicitly leaves alone this attempt that has been made to keep Achille Charles within narrow confines. And I'll come to that in a second. So that whilst we are reinstating the powers of GP to grant station bail, we're also taking into account the special circumstances now outlined in Section 5 of the Bail Act, so that we say that they will have no authority to grant bail where Parliament has expressly placed a higher threshold on the accused. And before my colleagues opposite jump on me for this, if you look at the decision of Justice Gobin in the case, what she says is this. She says the power of justices of the peace to grant station bail to persons charged with indictable offenses, and then there are some important words. What she says is, subject to any statutory limitation, is restored with immediate effect. So, I mean, it's obvious to me that she was making an exception to contemplate precisely what we've done. And if you go down to paragraph 63 of the judgment itself, she says, it is not in every indictable case that a JP would be entitled to grant bail. Mr. President, I therefore commend the bill and the amendments to this Honorable House, and with those few words, I'd like to...
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. The Honorable Faris Al-Rawi, Senator Faris Al-Rawi.
Thank you, Mr. President. I thank the Honorable Attorney General for piloting this debate. Permit me, in the scarcity of 45 minutes, to be as direct as I can. We received the bill as amended in the House of Representatives and began preparations. And it turns out that yesterday, very important amendments were circulated to the House, to the Senate. Those amendments, unfortunately, I confess, came to my attention at 8 o'clock this morning. I think they are very important amendments and are very worthy of consideration. But I wish at the outset to state that those amendments are very far-reaching in terms of the original bill and that which involves the amendments as we're now debating together with this. I do thank the Attorney General for circulating those amendments. That was very considerate of the Senate's time. We're dealing with two issues effectively in this bill, as amended and as proposed to be amended at committee stage. The first is the issuance of search warrants. The second is the issuance of bail. If I state plainly the position that I asked to be considered this morning, it is that the opposition has taken the view that the amendments as it relates to the inclusion of justices of the peace with respect to search warrants ought not to prevail today for the reasons which I propose to go into shortly. However, there is no objection, at least from my point of view, waiting on this debate to unfold, in relation to the issue of bail and justices of the peace being statutorily clothed with their common law rights and obligations and privileges as reflected upon by Justice Gobin in the case of Joel Alexander and the Attorney General. With those two mischiefs from a legislative point of view tabled, permit me perhaps to address the latter issue first, which is that of bail. Now, in the case of Joel Alexander and the Attorney General, which has been concluded, I take it from the contribution of the Honourable Attorney General that there will be no appeal to this case, so therefore we're not traversing any sub judice rule. I think that the Honourable Attorney General is correct in surmising that there ought not to be an appeal to this case, and therefore this case, even at the High Court, stands paramount. It's quite interesting that the judge in this case, Justice Gobin, is perhaps the go-to person on bail in the first place. She's made quite a few pronouncements in relation to bail. I, too, like the Honourable Attorney General, harboured serious concerns as to the constitutionality of the automatic exclusion of bail for murder and for other offences, as came forward from the 1996 Bail Act and continued into force. For the same reasons, whilst I was in the Senate in the period 2010 to 2015, I cautioned then Attorney General Ram Logan as to the need for sunset clause to prevail, because I always felt, firstly, that the law wasn't necessarily saved law. Secondly, that any attack against the fact that it was not saved law would be trumped, would succeed on the basis that bail as a common law right had existed for quite some time, and therefore you were skirting interpretation from saved law within the meaning of Section 6 of the Constitution. Achille Charles came along. Indeed, I was Attorney General at the time when that case came and went to the Privy Council, and I felt that it was bound to be a conclusion by the Privy Council that Section 5(1) of the Bail Act would fall, that you could not deny the right to bail. But nonetheless, we were carrying amendments passed, as the Honourable Attorney General said, since kidnapping for ransom had reared its head in a sustained way, but even prior to that, since the 1996 codification of no bail for murder, etc., had happened. With that said, the Achille Charles case, the Privy Council authority, says that the common law prevails in respect of the grant to bail. The reversal of the burden in consideration of bail was something that I introduced as Attorney General, specifically as an amendment to Section 6 by the inclusion of a new Section 7A, which said that the defendant would show cause as to why he should get bail. We borrowed that from Canadian jurisprudence and jurisprudence elsewhere to provide constitutionality, which we believe holds proper muster. That was repeated in the 2024 bail amendments and came to take root. The 2024 bail amendments came about because when the bail legislation could not be continued in terms of a sunset clause being denied, we had to go back to the entire law as it stood at 1996 plus one amendment. The consideration of Madam Justice Gobin in relation to bail in the Joel Alexander case is, I agree with the Honourable Attorney General, very important. I wholeheartedly support the conclusions of the court, but I want to remind that the conclusions of the court really was not that the law itself was ultra vires. The judge at page 29 ruled that there was a declaration that section 10 of AJIPA did not have the effect of removing jurisdiction of justices of the peace to grant station bail to persons against whom charges were laid indictably. Secondly, the judge ruled that the policy which removed the power of justices of the peace to grant bail in such circumstances is declared to be null, void, and illegal. The judge held that the power of justices of the peace to grant station bail to persons charged with indictable offences is restored, subject to statutory limitations with immediate effect. The judge, in making those declarations and so holding, was effectively setting aside the way in which the law was operationalized, both by the Trinidad and Tobago Police Service and by way of policy prescriptions that revolve around it. And that is squarely met by the fact that it had not been tested. Now, I can say now that as Attorney General then, I developed the policy in relation to the amendments that came in 2023. That's Act number 12 of 2023. And there were umpteen stakeholder contributions which occurred then. So for the record, Mr. President, AJIPA was born in 2011. We had serious problems with when it was brought into effect, including the premature operationalization of Section 34. It was amended in 2012, 2019, 2019, 2019, 2020, 2020, 2020, 2023, 2024, 2024. 10 times, not 9. I was a participant in every single one of those amendments. And in relation to those amendments, Mr. President, I can say that there was very deep consultation. And that deep consultation actually is part of the records of the Attorney General, no doubt. But from my recollection, it included, at the very least, 24 consultations with key stakeholders. In every one from the Ministry of National Security, the Trinidad and Tobago Police Service, the Judiciary, the Office of the Director of Public Prosecutions, Senior Counsel, the Public Defenders Division, Commissioner of Police of St. Lucia, Director of Prosecutions St. Lucia. We went extraterritorially. And under the convened Justice Committee sector group, which the Honourable Chief Justice chaired, we sat and we went through clause by clause, section by section, the AJIPA legislation. Nowhere in those reflections was there ever an intention of amending the Summary Courts Act and the Summary Offences Act such as to deny bail by a justice of the peace. Nowhere. Instead, the bail was preserved specifically, as the Honourable Madam Justice Gobin held and reflected upon in her ultimate determinations. Because the Honourable Judge correctly pointed to what was contemplated in those consultations, that bail would continue in respect of summary offences, that justices of the peace would have concurrent jurisdiction with magistrates, etc. Now, what the judge very usefully did in the Alexander case was to separate a very important point. The judge said, look, the constitutional right to freedom in Section 4 of our Constitution, the enshrined right, has to be borne in mind when you look to the practice of justices of the peace in that station bail at the moment at which you are arrested is still a very important factor. And the judge went through the Alexander circumstances of being charged for obscene language and resisting arrest, and ultimately spending several days in prison because he couldn't access a master because of long weekend or other factors. And what the judge held is that on the basis of the law as it relates to implied repeal, on the practice as it existed, on the common law factor, on the law of construction, being excluded from pepper and heart, meaning you couldn't go to the Hansard to look for it, but you could construe the law other ways. The judge said, look, the policy that was adopted by the police and by the judiciary of insisting that indictable offenses, any bail applications with respect to charges for indictable offenses, had to go to the master, and excluded by that practice the access to a justice of the peace for 24/7 access to bail, as the judge put it. The judge held that that surely could not have been the intention of the Parliament, because the judge correctly referred to A, the position of implied repeal, B, that it must be express if you're dealing with that, C, that the Parliament had the power to treat with creatures of statute, meaning masters, registrars and clerks of the court. In all of those creatures of statute, the Parliament could deal with its position, but the judge felt and held, and I think correctly so, that justices of the peace had to be put into a different position, ultimately because we're talking about the fundamental right to freedom. Now, what was interesting as well is that the judge also reflected upon doubtful penalization and really said that you couldn't move to penalize something if it wasn't expressed. So the simple position is this. The judge said, if there wasn't an express ouster of justices of the peace with respect to bail, the judge held that the policy which ousted justices of the peace was wrong. Because the law itself, all of the amendments to AJIPA, and particularly Act number 12 of 2023, did not expressly remove a justice of the peace for the purposes of bail. Now, in reading the judgment of Madam Justice Gobin and Joel Alexander, I see that evidence was submitted on behalf of the Office of the Attorney General. I have not seen that evidence, but it seems that that office went on to speak to what the policy was. I want to say now, in relation to marrying the two issues of bail and now search warrants, the specific policy that was adopted through umpteen consultations over a number of years was with respect to the removal of the power of magistrates and magistracy registrars and clerks of the court and justices of the peace with respect to search warrants. And why was that the case, Mr. President? That was the case because the issuance of search warrants also affects another very important right. And again, we go to Section 4 of the Constitution, Enshrined Rights, and we're looking at the right of an individual to life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof except by process of law. We're also looking to the right of an individual to respect for his private and family life. And when we look to those two particular enshrined rights, and we borrow the way in which Madam Justice Gobin looked at the fundamental right in relation to bail and held as she did, and I think correctly, we must now enter into an exercise of considering the aspect of search warrants being issued, in our case, in the opposition's position, by justices of the peace. We consider, based upon the policy followed for over 10 years of participation, that matter, and I note the Honourable Attorney General indicated to us that he had an urgent matter to attend to, so that we're to take no offence by his temporary departure, and I accept that. But we note in relation to the 10 years of policy that there was a deliberate consultation and perspective on, in particular, persons other than a judge or a master issuing search warrants. Why? That's to be found in the AJIPA Act itself. And that's to be found in Section 5 of that Act. You see, Section 5 is where a master is satisfied on proof of certain factors. The master may issue a warrant for a search. The search warrant may authorize one or more sets of premises specified to be searched. Any premises controlled or occupied specified in the warrant if the master is satisfied that you can't ascertain what the premises actually are. In other words, then you have a roving search warrant provision, a very wide position. Now, the Honourable Attorney General challenged the Parliament to say whether there's any mischief in relation to justices of the peace, and I can say so, yes. One needs only reflect upon the dicta of the court in the Brent Thomas matter, where the Honourable Judge, in deciding that case, said no justice of the peace effectively should have issued those search warrants, and he referred the matter to the Justices of the Peace Association. The key for discussion here today is, are we satisfied that allowing the Justices of the Peace the power to issue search warrants, which are roving, which are wide, and which are continuing, because we fundamentally changed the law with respect to search warrants in the last 10 years. Is that acceptable in the context of the fundamental right for deprivation of property, etc.? In fact, we heard the Honourable Attorney General refer to a case that I haven't heard for a very, very long time, and that's the case of Entic. In fact, I will say no. The first time I heard that case was from the lips of the Attorney General when he was my lecturer at law school. It's a long-standing case. It is the 18th century jurisprudence that no man should allow anybody to enter his clothes without permission. So here we have the search warrant positions, and the policy which the government, judiciary, DPP, law association, public defenders, other governments in the Caribbean, the 28 people consulted, the policy which you came up with was, because justices of the peace are not clothed with judicial authority, in this instance with respect to search warrants, and by that let me qualify it. I don't mean judicial authority in the sense of a failure to acknowledge it in the Summary Courts Act or elsewhere where they have the power to act as justices along with magistrates, but insofar as they are not protected by mechanisms such as determined in Hines, that is by a Judicial and Legal Services Commission, or with specified conditions for qualifications or for discipline or for record keeping, the state and condition of justices of the peace in this jurisdiction, in light of the very draconian power that we created as a parliament under Section 5 for roving and wide search warrants, the policy decision was to exclude justices of the peace on purpose. We also included the removal of magistrates, magistracy registrars, and clerks of the courts, because there was an attempt to streamline indictable offences to the High Court. Now, it wasn't that that was going on in a vacuum, because I can tell you, Mr. President, I listened to the debate in the House, and I heard a most untruthful submission from the Minister of Legal Affairs, the Honourable Saddam Hussein, saying that nothing was done in relation to justices of the peace. They just left it like that. Ridiculous. I personally sat, after instructing the Law Reform Commission, to develop the Justices of the Peace Bill 2023. It's there in the Office of the Attorney General, now transferred to the Minister of Legal Affairs. He should have known very well, clearly didn't do his homework. The Bill for Justices of the Peace 2023 is a profound piece of legislation. And the intention was that we would upskill justices of the peace. We would, in a bill containing 12 parts and 60 clauses and 7 schedules, that we would insist that justices of the peace have legal qualifications, or if they were existing justices of the peace, that they had a certain tenure in office. We would subject the approval and functions to act as justices of the peace to a Justices of the Peace Advisory Board. That advisory board would scrub the Justices of the Peace's qualifications and standing. That advisory board would report to the minister. The minister would then consider. So this was something very different from the creation of justices of the peace under the summary courts legislation. Because justices of the peace at present are simply appointed by the president. It is not with discretion. That means Section 80 of the Constitution applies. That means the cabinet effectively effects the decision. And the cabinet can, in all circumstances, delegate authority, and in fact, the authority was delegated to the Attorney General. So right now, justices of the peace, and I make no aspersion against the Honorable Attorney General, he, like every other Attorney General, has the power to appoint justices of the peace. But we were moving away from a position of no qualifications, no protection by the Hines backing, meaning a judicial and legal services type of independence. In this Justices of the Peace Bill, we were moving to disciplinary action, reporting requirements. The Justices of the Peace had to file anti-money laundering, counter-terrorism financing, countering proliferation financing forms, which were kept private. There was a full register for public examination. They had 3 years of qualification and licensing, after which they must have a reapplication process. It was a profound series of amendments because the intention was always to reintroduce justices of the peace once they were clothed with protection, which gave protection to the fundamental right in Section 4 of the Constitution of the right to property. Now, Justice Gobin, in her decision, was reflecting upon the words of Mr. Justice Barrow in the case of civil appeal Rihanna Lorick and Joanne Pantin versus the Attorney General. And the words that she quoted at page 1 of her judgment, the constitutional rights conferred by Section 4 and 5, and in particular, in this case, the right to liberty, are hard-won rights. The judge was saying about the paramountcy of Section 4 of the constitutional entrenched rights. This can easily be applied to the right to property. It follows with the Entic case, the 18th century case, that you should not allow somebody into your clothes, meaning your property, without proper authorization. But when we look to the massive expansion of the power of search warrants, we, by dedicated decision after deep consultation, took it to the point where we excluded, in particular, justices of the peace. The case of Brent Thomas proves that justices of the peace can issue warrants. Now, let's reflect upon a law that has just come into passage. The FATF Compliance Bill amendments gave the power for undercover operations to the Trinidad and Tobago Police Service under the Mutual Assistance in Criminal Matters Act, under the Anti-Terrorism Act, under the Financial Intelligence Unit Act. Full civil and criminal immunity, blanket, no conditions. I circulated, with your permission, the control operations law that we drafted, that I set into draft, which showed why it should have conditionalities and the use of a warrant to go undercover with cautions and supervision by the court. It was not accepted. The Honorable Attorney General gave an undertaking at the time that he would look at it, that there was merit in it. But today, are we going to give search warrants to a justice of the peace, having watched what happened in Brent Thomas, unmoving and complete position, ultimately to give full civil and criminal immunity from prosecution to police officers and other officers under the 4 laws I've quoted: Trinidad and Tobago Police Service, Mutual Assistance in Criminal Matters Act, Anti-Terrorism Act, Financial Intelligence Unit Act. We are on this slippery slope where the best intentions may cause problems. And therefore, I have a heartfelt reservation against expanding the powers of justices of the peace being included in the category of persons who can issue search warrants. If there was an amendment simply to remove justices of the peace from search warrants, we would have no problems. Why? In every single bill, in my tenure, I passed over 600 laws as Attorney General. In every debate that I came to the Parliament on, I brought data, figures, statistics, particulars of consultation. I put it on the record. Why? Because I was very concerned to ground the proportionality justification in case of a challenge. I want to remind you, Honorable President, that whilst the government last in position was there, and whilst I was Attorney General, there was a constant refrain of proposed attack on the use of the case of Surat, that is proportionality. There was a threat every single debate. We'll overturn it. We go into court. You and Surat, you had to get a 3/5 majority. This is unconstitutional until we went to the Privy Council in the case of Suraj, and the Privy Council upheld the entire legislative agenda which I led and which the PNM prosecuted to go by proportionality as justifying the reasonableness of legislation. In the failure to produce statistics here today, we have no genuine reflection on what the statistics show us. We are to just accept. I read the debate of the Honorable Attorney General in the House carefully. He anchored his position in the fact that there was a need for search warrants in this state of emergency. That caused great alarm for me. That caused great alarm for me. We have treated summary offenses and indictable offenses almost indiscriminately. There's some very heavy penalties for summary offenses and terms of imprisonment. Sort of akin, if you look to the Copyright Act, you look to other positions, you see $1 million and $2 million summary offenses. We have to be careful to distinguish the line between indictable offenses and summary offenses, but an indictable offense is nonetheless regarded in law as a more serious category of offense than a summary offense. And in respect of the indictable offenses, interception of communication being one of them, search warrants in general being one of them, anti-terrorism, anti-gang, it's very wide, Mr. President. We would be effecting an irresponsibility to revert to the inclusion of justices of the peace. I can accept, philosophically, the inclusion of magistrates and magistracy registrars and clerks of the court. Why? When I was Attorney General, we took the deliberate step to eliminate justices of the clerks of the court who were unqualified, had no legal backing. Effectively, they were breaching the Legal Profession Act by engaging in law when they couldn't. We eliminated that and we created magistracy registrars and clerks of the court so that they would have legal qualifications and supervisions, etc. So that's an entirely different class from the justices of the peace. You need only to go to the Summary Courts Act, Chapter 420, you'll see the qualifications for a master, you'll see the qualifications for magistrates. For magistrates, you see it in 420. For a master, you see it in the Supreme Court of Judicature Act. They are clothed, they are supervised, they are accountable. The justice of the peace in Trinidad and Tobago, without a law such as the Justices of the Peace Bill 2023, is dangerous in the context of indictable offenses. Because when you look to the breadth of search warrants under Section 5 of AJIPA, multiple premises, even if you can't name them, if they're owned by somebody and you find out that they're owned by somebody, we have a search warrant for X, we found out X has a property that is owned, we go in there. By a justice of the peace, when you read Brent Thomas, what is the Justice of the Peace Association going to do to discipline that Justice of the Peace that granted it? Mr. President, without being pejorative in any expression to justices of the peace, I've seen drunk justices of the peace issue warrants. I'm entitled to speak to my own experience. What can you all tell me? This is something that I know for a fact. Dangerous. The key is, Mr. President, we have to, today we're discussing a very important bill as proposed to be amended. It's apparently very short. It looks very innocuous. It appears to be a debate on just resource constraint. It is not that. There are divisible avenues in this bill. The clarification of the law by statute to statutorily codify the interpretation of Madam Justice Gobin in the Alexander case, 100% correct. Now is the appropriate time to do that. It doesn't matter that it came late to us. The fact is that the judgment just came. The Honorable Attorney General is not going to seek to appeal it. We have an opportunity now. Agreed. The issue of search warrants. How much time do I have, sir? Thanks. The issue of search warrants is a different category. I genuinely believe that the Justices of the Peace bill, as drafted, it's an excellent bill that is in the Office of the Attorney General. Thank you so much, sir. It is in the Office of the Attorney General. It should be in the hands of the Minister of Legal Affairs, the Honorable Saddam Hussein. It appears that it's not, because he went on a tirade which was untruthful in light of the fact of its existence. But we need to clothe Justices of the Peace quickly. And Mr. President, I don't think I need to belabor the point. Our simple closing submissions are, one, there are two mischiefs in this bill to be treated with. The second of which, Clerk, Julia, the second of which is the inclusion of Justices of the Peace for the purposes in particular of station bail and other bail aspects to be reverted to what the Judge, Madam Justice Gobin, has said, which I agree with. The judge never held that Section 10 of AJIPA was unconstitutional. The judge didn't reflect on the policy of the law. The judge simply said that the practice used by the police and the judiciary was wrong and that Justices of the Peace should be allowed to continue with their common law duties. The first mischief is the inclusion of a wider category of persons to authorize search warrants under the Administration of Justice Preliminary Inquiries Act. That could only be in Section 5 of that Act and any other laws that permit it. And in that regard, the inclusion of Justices of the Peace is objectionable because of the evidence that you have in matters such as the Brent Thomas case and many more matters. Our recommendation, Mr. President, is that we simply remove the reference to Justices of the Peace with respect to the grant of search warrants, and the opposition would be very happy to support those particulars. Mr. President, I look forward to observations coming from the Senate as a whole, and I thank you for this opportunity.
Senator Sophia Chote, SC.
Thank you, Mr. President, for the opportunity to contribute to this debate. We are being asked today to look at a proposed amendment to Section 10 of AJIPA. I'm sorry, I don't know why I'm getting feedback. It may be that I'm standing too close to the microphone. Section 10 of AJIPA, which basically says that the powers which a master now has in relation to the issuance of a search warrant should be broadened to allow certain other office holders to grant search warrants when applications are made to them. So what the proposed amendment is saying is, let's allow magistrates to grant search warrants. Let's allow magistracy registrars to grant search warrants. Let's allow court clerks to grant search warrants, and let's allow Justices of the Peace to grant search warrants. Now, I must confess that I learned a lot by reading the account of the debate in the lower house, and in particular, the contribution of the Minister of Land and Legal Affairs. Because I think what the Honorable Minister very candidly, and I think he should be commended by us, by all of us, for his contribution, what he very candidly set out to this country was the state of affairs in which the Justices of the Peace had found themselves after all of these years. And he very candidly, and I would say that took a lot of courage from a minister of government, because he explained that, listen, we are here asking for this legislation, but I'm not hiding from you the fact that this is the state of affairs with respect to justices of the peace. He brought to our attention, for example, that justices of the peace were not even properly listed. And under his ministry, I see that in May of 2025, he had gazetted a list of what the ministry had as justices of the peace. But, Mr. President, I have been around for so long now, even I, looking at that list, can say that list which the ministry has is incomplete, because I identified at least one, possibly two people deceased who are still listed on the list that the ministry has. And I'll tell you why I think that's a dangerous thing. It's because, you see, there is no responsibility on the part of the Justice of the Peace or the Justice of the Peace Association to advise the ministry. Let us say a Justice of the Peace has become incapacitated, he has mental health issues, or he's got a stroke and he is in hospital and he can't discharge his duties and that kind of thing. There is no one with the responsibility to advise the ministry of this state of affairs. And in fact, no one responsible to even advise the ministry if somebody has died. So this is why, while with the best interest of the country at heart, the Honorable Minister sought to tell us, well, look, you may not have known before, but I'm telling you now in May 2025 that this is the list we have of justices of the peace. Even his list was inaccurate. When I looked at the gazetted list, I also made a very startling observation, which is to say, there is someone on that list with a case pending before the court, charged with a very serious matter. So how are we going to deal with the population of the list and the fact that we are giving broad powers to justices of the peace without knowing the background information or having a system in place so that the ministry under which they fall will be up to date and will know how to act? Now, again, unfortunately, because I've been around for so long, I have come across instances where there was a justice of the peace who fell ill in a certain district. And while the poor man was there, ill, not knowing what was going on around him, it appears as though some clever police officers took it upon themselves to, it appears, I say, to take his stamp, and search warrants were issued with that justice of the peace's stamp and a signature. So it means that unless we have a system up front which is accountable, I cannot in all conscience, and pursuant to the prayer which was said at the start of our proceedings this morning, I cannot in all conscience support justices of the peace having the power which AJIPA gives them. Because Senator Al-Rawi, my friend Senator Al-Rawi, was very correct when he made the observation that what Section 5 of AJIPA did is Section 5 turned the power of search into a very draconian one. And I suppose the saving grace there is Section 5 was saying, okay, we are giving a judicial officer the power to authorize searches, but we are only giving that power to certain people because they have the training, first of all, so they will know what they are supposed to be considering, but also because they are accountable. If they act improperly, they can face disciplinary action. What disciplinary action does a justice of the peace face when acting improperly? We have a plethora of cases which have gone through the courts. And again, what usually happens when a police officer goes to a justice of the peace for a search warrant? First of all, what the cases show us is this. The police officer tends to be doing, unfortunately, what has now been considered as appropriate, but it's actually wrong in law. So the police officer goes and he says, I'm acting on instruction. So he fills out a form, which is called a complaint. He goes to a justice of the peace. The justice of the peace takes the form, reads it, more often than not doesn't ask a single question. The police officer raises his hand, he takes an oath, and there you have the power given to the police to carry out searches under the very wide powers contemplated by a JIPA. I would say that is a frightening contemplation or possibility for the citizens of this nation as a whole. Mr. Thomas, as horrible as his circumstances were, at the end of the day, had the benefit of a lawyer, had the ability to engage a court, had an attorney general who was fearless enough to say that we are not going to contest his application. What does your average citizen have when confronted with a search warrant obtained in these circumstances? I think common sense will give us the answer to that. Now, I want to go back a little bit to why I called a JIPA draconian. Because a JIPA said, listen, you can search premises, but now I'm giving you the opportunity. If when you go there, you see anything that causes you to determine that you want to search 2 or 3 other people's homes or businesses, you now have that power. So the search warrant is not confined to the premises. It may go on to other premises, which would include homes, businesses, and so on. The search warrant can permit multiple searches. There is no time limit set out in the Act as to how long that period of search must be. It simply says multiple searches, and the master has the power to say, well, you can carry out your searches within a 2-week period, a 3-week period, whatever it is. But you see, these nuances are important because it assumes, I think a JIPA assumes, that the person giving consideration to the application for the search warrant will take issues like reasonableness into account, may ask questions of the officer applying for the search warrant, may say, look, listen, I am not satisfied, come back with some additional information for me. Is that what happens before a justice of the peace? The answer is no. That is what our lived experience tells us, not only as lawyers, but I'm sure as police officers, as citizens of the country, this is what happens. Now, this problem is not new. As far back as 1997, when the Honorable Attorney General at that time was Mr. Ramesh Lawrence Maharaj, Senior Counsel, Mr. Maharaj recognized that what justices of the peace were doing was that they were hanging around the prisons and approaching the relatives and friends of incarcerated persons so that they could offer their services to grant bail. They were touting to grant bail outside of the prisons. So what the Attorney General at that time did is he said, listen, let my ministry, and he did in fact do it. It is such a pity that it did not become legislation in any form. So what we have now is a good guideline, but it's just moral suasion. He created a handbook for justices of the peace. So he said, look, if you're dealing with confessions, justice of the peace, as part of your duties, follow this. You're dealing with ID parades, follow this. You're dealing with search warrants, follow this. But very importantly, in that document, and I think it is such an old document, it can't be found digitally. At about page 62 to 63, he set out a code of ethics. I'm very disappointed to say, and again, I can speak from lived experience, that because so much time has passed, not even attorneys know that this handbook exists. The newer appointees as justices of the peace don't know. I myself have asked questions in court and trials of justices of the peace. Have you seen the handbook of justice for justices of the peace? They have heard of it, Mr. President. So not even justices of the peace have an idea of what we as a country, and today what we as a Senate require of them. So in no sense of the word, when you look at the word accountable, in no sense of that word or the understanding of that word, can you get the impression that this is a person holding a public office with the capacity to know what is required of him or her under a JIPA, with the ability to comply with a JIPA's demands, to understand that he or she must have systems in place to reflect that accountability. Because this takes me to another point. I understand that the problem is that police officers may find that in terms of when they want the warrants and so on, it may not be easy to access a master. I had thought this problem had been addressed because I had thought a system of emergency masters, just like you have emergency judges, had been put in place for emergency applications like this. Now, it may be that it is no longer in place, but it certainly appears to be a kind of practical solution to the issue which we face. We have also not been told, listen, police officers wanted warrants, let's say on 100 occasions, and they only got them in 10 because they couldn't find a master. So saying that this is what the police want, I mean, I have a lot of sympathy for, because certainly we want to make sure that crime is fought effectively. Who can disagree with that? But it's not just what the police want. Come and tell us, listen, there's a real problem here accessing masters. Has there been communication with the judiciary to see if it can be resolved by having emergency masters? If so, why that is not working? And this is why perhaps we want to broaden the category to include other people. I'm quite happy to agree to broaden that category, as I say, to include everybody else but justices of the peace, because they are unregulated. I forgot to make this point when I was talking about the process used by a police officer who goes acting on instructions sometimes to apply for a search warrant. You go to that justice of the peace afterwards, and you try to find any record of what occurred during the course of that application, and you'll find none. Because what happens is the justice of the peace goes with the complaint, another document, and the warrant, and leaves with it. All that the justice of the peace, if the justice of the peace has a notebook and wants to write in it, he or she can say, police officer, registration, rank number so-and-so came before me at this hour of the night, sought a search warrant for these premises, and it was granted. There is nothing else that the Justice of the Peace can do. Magistrates, when applications now come before them, in other matters where they still have the power to grant warrants, they very often keep their clerks in the room with them. They keep their note takers with them. So there is a record in the judiciary by the officers of the court, and there's the facility for that. A justice of the peace, if you go after hours, is really a one-man operation. And that doesn't lead to accountability, in my respectful view. It doesn't lead to transparency. But what it can lead to is very dangerously, with no restriction and no protection whatsoever, giving the power to justices of the peace to grant search warrants where they don't even know what the search is going to entail. When I looked at a JIPA as well, I thought, well, how come the police are having this problem? Because a JIPA basically saved those pieces of legislation which allowed justices of the peace to carry out searches. So I did a quick check because I thought, okay, high crime, two things which immediately come to mind would be guns, drugs. And that power is still saved. Under the Firearms Act, unless I'm misreading it completely, and under the Dangerous Drugs Act, justices of the peace can still grant search warrants. So how is the police being compromised here? Which warrants are they asking for that they are not getting? I don't like, with all due respect to all of my colleagues in here and to this honorable chamber in which I speak, but I don't like the use of generalizations in terms of somebody wants something, so we've come to Parliament and Parliament should give it to us. That's not why we are here. We are here to scrutinize legislation to ensure that all our rights, because we too are citizens, all our rights are protected. Now, I was so happy when the Honorable Attorney General referred to the case of Central Broadcasting Services Limited. And for the record, I'll give the citation. CV 2019-02135. Now, I will refer to only 2 paragraphs of that case. Excellent decision, because it sets out the history of search warrants and so on. What is intended, what is the purpose, but very importantly, it sets out the difficulty, or it identifies the difficulty that someone being asked to issue a search warrant may encounter. So this is the Honorable Chief Justice speaking in his former incarnation as a High Court judge. And he says at paragraph 33, and Mr. President, I ask your permission to just briefly read it. What all of this points to is that scrutiny of the process by which a warrant has been obtained and the manner in which it is executed is an important safeguard for a citizen in a democratic state. Here, the entity is a broadcasting company which is accorded legal rights under the Constitution and laws of the country. He then went on to say at paragraph 41, further, in a democratic state, the search of a media house can have a chilling effect on the society. The power of search can be used for an illegitimate purpose of intimidating or silencing critics, including invading the privacy of individuals who are present or employed at the media house, a free media operating in an environment, and he continues to talk about the fact that this dealt with a particular right, in this case, freedom of expression stroke freedom of the press. So this case really highlights or makes the point as to why inclusion of justices of the peace in this proposed amendment is dangerous. Because do you really, or do we really expect a justice of the peace with no legal training to say to himself or herself, well, this search warrant has to do with a media house. Now, I must keep in my mind that this has to do with the issue of freedom of expression. Let me see what questions I can ask to make sure that all is well with what the police officer is providing me with. How will a justice of the peace who simply makes a brief application with 2 recommenders to the honorable ministry and then to the president, how on earth will a justice of the peace with no knowledge of the law whatsoever even know which questions to ask? And yet we are saying, and the courts have found, in that case, the court alerted us, in this case from 2019, alerted us to the danger that you encounter when you have those who are not qualified, who do not have the experience, who do not even know what is the extent of the power that they are exercising when they allow a warrant to be granted. This is what the court is alerting us to. This is the danger that the court identified for us. We didn't have to think of it ourselves. The court, just as Justice Gobin did with respect to bail a couple of weeks ago, the court identified it for us. Now, I also note in a JIPA, and if I may just have one moment here, that section 5 was so very long, it's pages and pages. So section 5A says, where a search warrant has been issued under this act for the purpose of obtaining communications data and so on, and material under the Interception of Communications Act, it talks about what happens where that kind of application is made. So is this amendment in section 10, and I ask the question because I'm not entirely sure, is this proposed amendment under section 10 also going to allow justices of the peace to issue search warrants for material under the Interception of Communications Act? I would think that's in light of all that I have said, I would think that would be an extremely dangerous situation. Now, I know sometimes we come here and we say to ourselves, look, you know, we are part of the Commonwealth. If justices of the peace in other places in the Commonwealth have certain powers and they have had them historically, and it's safe for us. We get a sense of safety from that, saying other countries are doing it and so on. And, you know, it's working for them, so we can follow suit. But in this case, when I tried to do a little dig, I realized that in the Commonwealth, you have a variety of positions with respect to how justices of the peace are created, how they are held accountable, what they are allowed to do, and what qualifications they are required to have. So if you talk about lay justices in the UK, for example, they can even hear and determine cases, but what nobody says or what people forget is they are assisted by legally trained clerks who are lawyers. So they have a support system in the law. So we can't say, look, the UK has lay justices, and they work out fine. So in Trinidad and Tobago, we're not asking for anything too different. Well, I say it's radically different. Jamaica, which was one of the territories cited, Jamaica has legislation setting out a code for justices of the peace and holding them accountable in certain circumstances. Guyana has bits of legislation. It's not all in one piece of legislation, but there are bits of legislation which govern how justices of the peace function. So we here, what do we have? We have a work product done by an excellent Attorney General in 1997, which unfortunately never bore fruit in terms of legislation to govern this sector, which we clearly wanted to continue to play a role in the judicial system. So there was no regulation, no accountability, no upgrading in terms of sharing of knowledge, because if you don't even know that a Justices of the Peace Handbook exists, what can we assume that you know about the law which you are being asked to apply? And it's all well and good to say legislation was drafted in 2011 and 2023. Quite frankly, that doesn't help me. That doesn't help the citizen, the average citizen. Let me call my hometown, Rio Claro, Union Village, Manzanilla. In places like those, where a police constable is treated like God, that doesn't help me to reassure them that when I stand here as a senator and I'm asked for a vote on this piece of legislation, that I have them in mind. Because I certainly cannot, in these circumstances, with all due respect, support an amendment which gives this broad power to justices of the peace. I think with respect to that group or that particular community, and it's not I'm here to throw shade on justices of the peace. They do serve an important function. But I think we are all agreed in here that they need to be upskilled, they need to be regulated, they need to be held accountable. This essentially was what the Honorable Minister of Land and Legal Affairs said in the lower house. So let's not put the cart before the horse. I don't know if, Mr. President, if the Honorable Attorney General will be amenable to this, but perhaps it could be up for consideration. Hive off justices of the peace. Have some means to resolve the issues which the Minister of Land and Legal Affairs told us about. Address it, regulate them, hold them accountable, and then we can have them included or given the kind of powers which we are being asked to permit in this proposed amendment. So with respect to justices of the peace, that is what I would like to say. Now, with respect to bail, I myself only saw it this morning, so I don't want to talk too much about, something that I have not really had the opportunity to look at too carefully, but it seems to me to be fairly uncontroversial. It seems to me that there is some accountability contemplated in the proposed amendment, because I note that one of the subsections says that when the Justice of the Peace grants bail, or if the Justice of the Peace grants bail, there must be some, the person must be taken before a master. So it means that there's oversight. There's oversight. So if a Justice of the Peace uses a land deed which is fraudulent, or takes or doesn't do his recognizance properly, or uses a surety who shouldn't be standing as a surety, then the master oversees that process. I think that is what the subsection is intended to address, and I'm going to take it at face value and say that that is what I understand it to mean. So if that is what is intended, then with all due respect, Mr. President, at this point in time, I don't see how I can have an objection to that aspect of the amendment. So, Mr. President, thank you for the opportunity to speak.
Yeah, Senator Desirée Murray.
Mr. President, I am grateful for the opportunity to contribute to this important debate. Let me begin by welcoming you back to this Honorable Senate. Your presence was missed, but I hasten to add that Madam Vice President exhibited very capable stewardship during your absence. Mr. President, I approach this bill as I do all matters of public policy, from the perspective of a medical professional and an educator, committed to standards, ethics, and institutional integrity. As a senior lecturer at the University of the West Indies, I am deeply invested in the principles of rigorous training, accountability, and the safeguarding of public trust. The Administration of Justice Indictable Proceedings Amendment Bill 2025 comprises only 4 clauses. Despite its brevity, it carries significant implications for the administration of justice and the protection of citizens' constitutional rights. In essence, it proposes to expand the category of persons who shall have and exercise concurrent jurisdiction with masters of the court to issue search warrants, and as per amendment circulated on behalf of the Attorney General late yesterday afternoon, to grant bail in accordance with Section 5(2) of the Bail Act. At first glance, this may appear to be simply a procedural or technical adjustment, but its constitutional weight should not be underestimated. Section 4 of the Constitution of Trinidad and Tobago enshrines the protection of fundamental rights and freedoms, among them the right to liberty, security of the person, enjoyment of property, and respect for private and family life. The proposed changes to the law must therefore be evaluated not only for their efficiency, but for their impact on our constitutional rights. A search warrant, Mr. President, is not a mere administrative formality. It is a powerful instrument, one that permits the state to intrude into the private spaces of citizens, their homes, and their personal effects. It is therefore essential that the authority to issue such warrants rests with individuals who are properly trained and equipped to exercise that power with the necessary care and judgment. In 2023, this authority was restricted to masters of the court, and with good reason. They are judicial officers who meet the highest standards of legal competence and impartiality. This bill now seeks to confer concurrent jurisdiction on magistrates, magistracy registrars, and clerks of the court, and justices of the peace to issue search warrants. While I understand and appreciate the rationale, namely to improve efficiency and reduce delays, because justice delayed is justice denied, I am concerned that without adequate safeguards, such expansion could dilute judicial oversight and risk the arbitrary exercise of power. Mr. President, it is worth noting that magistrates and magistracy registrars and clerks of the court are legally trained professionals. According to the Public Service Careers Portal, which is powered by the Ministry of Public Administration and Artificial Intelligence, a senior magistracy registrar and clerk of the court must be an attorney at law admitted to practice in Trinidad and Tobago. This qualification gives them the legal grounding to interpret the law and uphold constitutional protections. In contrast, justices of the peace, though they perform valuable and often underappreciated service, are not judicial officers. Their qualifications, training, and scope of practice vary widely, and there is currently no uniform framework to ensure consistency in their preparation or accountability. To draw a parallel from my own field, the medical profession, it would be unthinkable, inconceivable, and indeed negligent to allow someone without medical training to prescribe chemotherapy or administer intravenous anesthesia, or to allow an untrained junior doctor to perform an emergency cesarean section. So, professional prudence dictates that authority must be matched to training, competence, and ethical judgment. The same principle applies here. The power to issue a search warrant is much more than a clerical task. It demands not only the ability to read and sign the document, but also to weigh evidence, interpret law, and balance competing constitutional rights. Mr. President, this is not a critique of justices of the peace. Many JPs serve with dedication, diligence, integrity, and commitment, often in very challenging circumstances. They often provide timely and neutral review of warrant applications outside of regular court hours or in remote areas, functions which are undeniably useful in improving access to justice. However, it is equally true that the existing framework does not guarantee uniform standards of training, qualification, or accountability among justices of the peace. Some are highly capable, but others have entered the office without formal legal education or adequate preparation. Indeed, as my learned colleague, Senator Chote, mentioned, during debate in the other place, the Honorable Minister of Land and Legal Affairs himself outlined several long-standing challenges facing the office of the Justice of the Peace. Among them, the absence of a modern, standalone legislative framework, no minimum qualifications for appointment, an outdated and opaque appointment system, no clear age or tenure requirements, weak oversight and accountability mechanisms, no enforceable code of ethics or disciplinary procedures, absence of continuing legal education or training, and limited jurisdictional coverage, particularly in underserved communities. Also, justices of the peace have no protection in terms of a commission governing them. With respect, Mr. President, those are not minor administrative gaps. They are structural deficiencies, and they call into question whether the profession, as currently constituted, is ready for an expansion of powers of this magnitude. The systemic deficiencies must be addressed before any expansion of powers is considered. It is worth recalling that as far back as 2001, the Justices of the Peace Bill was drafted precisely to address concerns following allegations of abuse and misconduct in the issuing of warrants. That bill, unfortunately, lapsed in the dissolution of the 6th Parliament, and successive governments have yet to see it through to completion. We now find ourselves in 2025 seeking to expand JP authority without first modernizing the legal framework that governs them. That, to my mind, and I agree, is placing the cart before the horse. There are also practical considerations. At present, there is no unified record-keeping system to track applications for warrants. A justice of the peace asked to sign a warrant may have no way of knowing whether another justice of the peace, or indeed a master of the court, had previously refused to sign. This could lead to inconsistencies and undermine public confidence. Mr. President, I am not opposed to reform. I support any measure that makes the justice system more efficient and responsive. But reform must be responsible. Expansion of powers must be matched with training, oversight, and accountability. If we are serious about strengthening the office of the Justice of the Peace, let us begin by passing a modern Justice of the Peace Act. Let us clearly define qualifications, establish transparent appointment and disciplinary procedures, and mandate continuing education. Only then should we consider reintroducing broader powers, such as the issuance of search warrants. I sense, Mr. President, that there is crossbench consensus on this issue. We all want a justice system that is accessible, efficient, and fair, but equally one that is principled and constitutionally sound. In that spirit, I wish to offer practical suggestions for consideration. The medical profession maintains an emergency on-call roster for consultants so that patients have the benefit of their training, qualifications, and experience. A similar system, if not yet done so, could be introduced within the judiciary. Masters of the court could be rostered on an on-call basis for urgent warrant and bail requests. Only if a master is unavailable would the authority then cascade downward to a magistrate, then a magistracy registrar, and only thereafter, if necessary, to a justice of the peace as the last port of call and not the first port of call. Let me be clear, I'm suggesting this especially for emergency situations, which is apparently where the issue lies. An on-call master could readily have dispatched with the granting of the bail in the Joel Alexander case and would have prevented the unfortunate circumstances that followed, as highlighted by Madam Justice Carol Gobin in her 15th October 2025 judgment. Structure would enhance transparency, preserve judicial oversight, and ensure that authority is exercised in an orderly and traceable manner. Additionally, this would ease the burden on JPs, particularly those in Tobago, who must sometimes travel to Trinidad to give evidence in related matters in the High Court. Mr. President, while I recognize the intent of the bill to streamline the administration of justice, I urge that we proceed with measured caution. Expanding the category of persons to issue search warrants beyond masters of the court is not the only solution. I respectfully propose two alternatives. One, an emergency on-call system for masters of the court. My understanding is that there are 12 masters, but it is unclear to me whether they cover the entire country. If nationwide coverage is explicitly granted, this would mean that 2 or at most 3 days per month of emergency on-call would be required. This can be instituted with almost immediate effect. And 2, training, oversight, and legislative reform so that justices of the peace can continue to play a meaningful role within a modernized justice system. The Justices of the Peace Bill should be brought to Parliament for debate and enactment, following which suitably qualified JPs can then be afforded expanded powers. This does not have to be an all or none law. Mr. President, I'll be circulating amendments reflecting my recommendations outlined in my contribution for consideration at the committee stage. I thank you.
Yeah, I'd like to propose that we take the luncheon break at this time. Now it's 12:46. We shall resume at 1:50 p.m. The sitting is now suspended until 1:50 p.m. Senator, the Honorable Darrell, Allahar, are you?
Mr. President, forgive me, I'm a bit out of breath because I had to run back here in time for you, so I'm not very fit. But Mr. President, thank you for allowing me to participate in the debate so far. Now, it has been a very good debate, and I think we can take stock thus far, and again, without prejudice to anything else that may be raised. So there are two issues. One is with respect to restoring the ability of justices of the peace to issue search warrants in indictable offenses. And the other is to confirm a decision of the High Court in the case of Alexander, to confirm the ability and jurisdiction of justices of the peace to grant bail in indictable matters. So there are two issues. Now, from what I understood from Senator Al-Rawi, he's not here yet, is that and perhaps Senator Brown can correct me, the opposition has no objection to the confirmation of the law in relation to bail, justice of the peace granting bail in indictable offenses, in that the decision in Alexander confirmed the law, and indeed it was a declaration in rem. If you look at the end of the judgment, it's a declaration in rem, meaning, for those of you who don't know, a declaration to the world that this is the state of the law. So we are merely confirming and codifying what the law is. So there should be no serious objection to confirming the law as stated by the Honorable Madam Justice Gobin. I don't think Senator Chote had a difficulty with that aspect of it, that limb of it. She didn't mention anything, and she's nodding, so I'm thanking you that you had no difficulty with it. I think it was a very good judgment. I don't think Senator Murray as well traversed that area, but I understand the concerns that she had generally, and we would be prepared to treat with those. But, Mr. President, at the outset, I think I must say that it is unfair today in this Senate to cast our justices of the peace as the villains in the peace, to pardon the pun. Senator Al-Rawi, and he's not here, he said that, and his words were, if I wrote them down, he said, "I have seen a drunken justice of the peace issue search warrants." More than one warrant. I don't know if he saw him do that in his capacity as Attorney General. I don't know. But if he saw him do that, did he do anything about it? I don't know. He's not here. Exactly. So, Mr. President, it's unfortunate. It's a sad day when we can come here and characterize our GPs as drunken. They have always been functionaries in our legal system. It is unfair, shameful, and, Mr. President, quite simply wrong. Yes. I think he should. Senator Chote, Mr. President, she spoke about her lived experience, which I acknowledge. Senator Chote has been a practitioner for many years and the president of the Law Association. And I was privileged to serve with her on the council. And I think she understands the issues here. And she spoke about her lived experience in relation to perhaps giving JPs a jurisdiction with respect to issuing multiple entry warrants in multiple premises. And we acknowledge that, and I want to thank Senator Chote for raising that and to tell her that later on in my contribution, I want to propose something which may put her mind at ease, or indeed the Senate's mind at ease. Senator Dr. Murray, very good contribution. She spoke about individuals who are trained and equipped, and she said that that would be her preference, and her preference being for judicial officers. And she said it was not a critique of the GPs. Now, with the greatest respect to Senator Murray, this is not a simple distinction of nurses and hospital attendants versus consultants and doctors. It's not as simple as that. We have had functionaries in our legal system for many years performing yeoman service where access to a judicial officer is not practicable and where, as Senator Murray would know, exigencies of situations require access to justice. Ironically, that is why there seems to be no objection to JPs being given back their jurisdiction to grant bail. If they are good enough to grant station bail for everybody in indictable and summary, yes, because of the liberty of the subject and so on, why can't they be good enough to issue search warrants in their common law capacity? It doesn't follow, Mr. President. But we will talk about some suggestions a bit later. But I think we shouldn't lose sight sometimes of the logic of the things that we say here, and glaring inconsistencies and elephants in the room. What's good for the goose has to be good for the gander. But notwithstanding all of that, Mr. President, I acknowledge the concerns raised by Senator Chote and Senator Murray. But I reject wholeheartedly, Mr. President, again, that GPs are a bunch of drunkards. And I similarly reject the notion that GPs are not mentally equipped or trained to continue to function under their common law powers, be it in granting station bail or issuing search warrants. Simple search warrants. Again, we will get to there. Now, Senator Al-Rawi, and he's not here yet. He's here? Oh, he's here. Speak of the devil, as they say.
It takes a while.
Okay. He didn't have to run to the chamber, but I'm happy he's here. And I think he chose his words very carefully, Mr. President. And he asked the rhetorical question of whether allowing GPs to issue search warrants in indictable matters was constitutional. So he asked the question. He didn't go so far to say that it was not. I know he chooses his words very carefully, most of the times. He said that he had, in inverted commas, a heartfelt reservation about them issuing warrants, search warrants. Those were his words. But he did not go so far to say, which he could have, that this bill should be passed with a special majority. Even though he quoted certain rights potentially that could be affected. He didn't go so far. And yes, I'm just saying what he didn't say. And there's a reason he didn't say it. Okay? I'm sure. I think Senator Al-Rawi knows and appreciates that the common law powers of justices of the peace to issue search warrants in indictable offenses have never been found. They have never been found to be unconstitutional or in breach of the separation of powers. Well, you're not a lawyer, so you won't understand. Because as far as the separation of powers is concerned, you see, we speak in a code sometimes. Senator Al-Rawi invoked the case of Hines, but he didn't go into any detail. And again, there's a habit of invoking cases but not going into detail. Every law student knows about the case of Hines, a case out of Jamaica and bail court. And we know it was a case, Privy Council judgment, which established that in our written constitutions in the CARICOM region, former British territories, there's an implied separation of powers and a distribution of legislative, executive, and judicial powers among the three arms of government. So he touched on Hines, but he didn't go any further. And there's an inside joke among law students that Hines was perhaps the longest obiter dicta in the Commonwealth. And all law students must, in their first week at UE, read all 100 pages of Hines versus the Queen. I don't know if Senator Al-Rawi read it. I know his professor is here. I'm not sure he read it, but I'm sure, did he? I'm sure he did, which is why he didn't go any further with Hines. He just flagged it, and he likes to use the word flag. He flagged it, and he just went on, because he knows that this is not in breach of any separation of powers. So why mention it? Okay? Hines is not a case to be invoked lightly, Mr. President. Senator Al-Rawi also invoked Surat. But I'm happy he did, because I think he knows that not every delegation of judicial or quasi-judicial power to a person infringes the separation of powers or requires a special majority. So I don't know why he did that, why he raised these red flags. Okay. Senator Al-Rawi invoked Brent Thomas, and I think Senator Chote did as well. But Mr. President, I think, again, with the greatest respect, we should all here be more concerned as to the abuse of executive power that happened in Brent Thomas. And the ministerial overreach, and I want to remind the Senate about that. So some people should not invoke Brent Thomas here at all. We've heard some concerns, and quite rightly, about accountability in terms of how this thing will operate. Senator Chote, Senator Murray, thank you again for your concerns. But I think, Mr. President, that, again, for the record, it is with respect incongruous of us here to object to JPs being restored to their common law power to issue search warrants in indictable offenses, but at the same time not object to JPs being able to grant station bail in both summary and indictable matters. I say it again, it does not follow. And I want to put on record some of the things that Madam Justice Gobin said in Joel Alexander, and I think it is important to say it. At paragraph 31 of her judgment, that is claim number CV 2024-03115, a judgment delivered on October the 15th, which was 5 days after the debate of this bill in the other place. She says, and I quote, if I may, "For decades in this jurisdiction, JPs have exercised their powers to issue warrants of arrest, police warrants of arrest, search warrants to grant bail to search warrants and to grant bail to persons who are charged at police stations and to take recognizances for decades, Mr. President." Mr. President, I want to also refer to another passage where she speaks about Mr. Alexander's concerns. He was the fellow who brought the action, where she says, "The devastating consequences of the construction of Section 10 and of the policy imposed by the executive for enforcing it are demonstrated by the facts of the case. Mr. Alexander's harsh experience reminds of the unimaginable brutality of the consequences of it. And it is hard to believe that a result such as Mr. Alexander's could have been contemplated by the promoters of AJIPA, when under the previous regime, generally, persons who were charged for indictable offenses, including relatively minor ones, Mr. President, had available to them a simple and swift procedure for obtaining bail at the police station, and one which did not require them to retain the services of an attorney at law. Routine access to a JP may have appeared as a simple administrative step, but underappreciated as it appears to have been. The intervention of a JP protected the following important constitutional rights of the accused," unquote. So today the general theme of the discussion today, under both limbs of what we have to deal with, the two issues I mentioned, is access to justice. And may I say, Mr. President, that access to justice not only means access of an accused to bail or to hearing before a judicial officer for the determination of the merits of his or her case. Access to justice also is about timely access by law enforcement to a functionary within the criminal justice system in order to issue search warrants to collect and preserve evidence. And we should not lose sight of that as well. So, Mr. President, I'm pleased to say that we have listened to some of the concerns thus far. And the Honorable Attorney General has asked me to convey to the Senate that with respect to the training of justices of the peace, and there's a concern about their training, justices of the peace can be trained and educated on what is required of them under JIPA. There's a Justice of the Peace Handbook, Stone's Justices Manual 2018, and of course, that was referenced by the Honorable Mr. Justice Budu Singh in the Central Broadcasting Services Limited case. And we would want to say that a proclamation clause can be inserted with respect to that aspect of it dealing with search warrants to ensure that such training takes effect and is done properly before that aspect of the law can be effected. So we can put in a proclamation clause to make sure that that training is done. Now, with respect to, we heard something about the Justice of the Peace Bill intended to reform the system of JPs. I want to remind the Senate that the Minister of Legal Affairs in the other place had indicated on October the 10th, 2025, to address the issue of wider JP reform. And he said, and I quote, "Training is one of the matters that we are looking at in terms of training. However, JOPAT, which is the Justice of the Peace Association, they undertake various training courses and so on." So training is something that we will look at and we will try to ensure before the law is proclaimed, and we will bring some amendments in relation to that. Now, in relation to the suggestions of bad character of JPs and so on, we always will have a problem with judicial officers and quasi-judicial officers getting it wrong. Okay? But there are avenues of appeal. There are avenues of redress. And that is what is called the protection of the law, one of our fundamental rights. I don't know, Senator Al-Rawi may recall many years ago, and it's so funny, he and I appeared in a matter together in which we stopped the execution of a search warrant on an attorney at law's office. And that was one of the avenues, and I don't know, he might not have remembered it. That's what you do. One of the avenues of redress. Very late at night, we had to move the High Court to stop a search warrant from being executed. And I think the Honorable Attorney General was the Attorney General at the time. He settled the matter. He settled.
I didn't see it. I know the book.
But he quite generously settled the matter. We never got our costs, though, but he settled the matter. And so we understand here, Mr. President, that there are avenues for redress. We have heard, Mr. President, the concerns, as I say, and we have especially the concerns of Senator Chote with respect to those sorts of search warrants where there is, let me just get it here. Where there is a repeat search. I think that, am I correct? Where the warrant issued by, you're saying that the warrant issued by the JP can authorize repeated searches of premises, yes? And that is we think that is a valid concern. Multiple searches. And we think that is valid, and therefore we want to propose an amendment to limit the power or jurisdiction of the Justice of the Peace in indictable matters to what was their common law power, i.e., not the extended powers that have been given to the masters and other judicial officers to authorize warrants for multiple searches of multiple locations. And we trust that that would satisfy those very valid concerns for which we're very thankful. I think Senator Chote as well flagged Interception of Communications Act and her concerns in that respect. And her question was whether the amendment under Section 10 was going to allow GPs to issue search warrants for material requested under that. I see Senator Al-Rawi is shaking his head. Yes? No? I say it's no. You're saying no, right? We can tell you that we've checked it, and the application of a warrant for stored data, communication data, and stored communication is one matter. And that is to be distinguished from, I think, what Senator Chote is speaking about, which is the warrant to intercept communication. That warrant to intercept communication requires the warrant be issued by a judge in chambers. No, no. That would be a judge in chambers, and that is not covered. That is not covered. Okay? Go ahead.
Thank you so much. Not to intrude on your time, thank you, Honourable Senator. If you could just please have a look at Section 5 of the Preliminary Inquiries Act, which runs concurrently, so that warrants under Section 8 and Section 11 of interception of communication, yes, it's before a judge, they're fine. Stored communication and other aspects in a JIPA mirror the Preliminary Inquiries Act, Section 5. So if you could just have a look at that, it'll help you perhaps in your reflections in further answer. Thank you.
Okay. So thank you very much, Senator. But I think Senator Chote, Senator Chote's concern was with respect to interception warrants. And the short point of it, and I thank you for your intervention, the short point is that it does not go as far as interception warrants, which a judge in chambers has to issue. So I think that should satisfy us as well. So, Mr. President, in summary, I think we have taken stock of some of the issues. I know we have other speakers in this debate, and we presented what I feel is a reasonable compromise while, I'm sorry? Yes, sure.
Would you consider giving way? The reason for my uncertainty, and I'm sure you'll be able to clear this up, is the interpretation section speaks to 5.1. So the Interception of Communications Act falls under 5.1. Yes.
We still have specific statutory provisions in the Interception of Communications Act. So the specific provisions would override the general ones. And those specific provisions are very, very clear with respect to a judge in chambers, with respect to interception of communications. So there's no need for us to tinker with it here because it's there. It's there. And we've checked it. I think the Attorney General is assuring me that they've checked it. And I hope that helps us. So at the end of the day, Mr. President, we've taken stock and we have a reasonable position. We have a position that is borne by logic. We have a position that is borne by judicial authority. And we have a position which I think the debate is going along a particular way, in that we can be out of here before the sun sets. So, Mr. President, you have a government, Mr. President, that is responsive to stakeholders and committed to the rule of law, a government that is committed to cleaning up the errors and omissions of the former regime in order to strengthen and improve the administration of justice. We are committed, Mr. President, to certainty of the law, and we are responsive, as is happening this afternoon, to matters where there is a judicial determination. And that's why we've come here very late with those amendments, because that happened in between the other place and here. And it was a good opportunity to put it here and to fix the law. We are responsive to the concerns of our colleagues. And we wish to say, Mr. President, that let's not run around like Chicken Little and the sky is falling. Lord Atkin had said in the case of Liversidge and Anderson that amid the clash of arms, the law is never silent, and the law is here. It's never silent. So the sky is not falling, Mr. President, for us today. Actually, the sun is rising, and I thank you.
I'd like to recognize Senator Melanie Roberts-Radgman.
Thank you, Mr. President, for the opportunity to join the debate at this time. And I'll definitely be quite brief. I think that the issues have been well ventilated on both sides. We've seen where the government has made efforts to address some of the concerns that were raised by the opposition and independent benches. See, the point of contention with this bill has less to do with the ends that are trying to be achieved, as was articulated by the Honorable Attorney General, and more so to do with the means of achieving those ends. And I think all three benches understand the concerns about the efficiency that the government wishes to address by bringing this amendment. But we also have our concerns about not so much what is trying to be addressed, but who the government is attempting to grant additional discretion to issue search warrants for indictable offenses. And we would have heard more so in the other place, and to some extent here, we'd have heard how very little is required currently for a person to become a justice of the peace. It's a letter from the applicant, resume, references, forms of ID, that kind of thing. And, you know, the easiest retort would be, well, other jurisdictions have it much the same way. In the UK, for instance, you don't have such formal requirements. And I hear that, but I say those places aren't Trinidad and Tobago. I also want to just put a pin in that area, because I'll come back to it, because I would have heard Senator Allahar indicated some promising developments based on the feedback that he would have gotten from both benches with regards to the training of the JPs. So a little bit further down, I'll address that and maybe implore some additional interventions I think will alleviate some of the concerns coming from both sides. In terms of the issue of formal training, I took a look at some other jurisdictions, for instance, Jamaica right up the islands, and it was noted that applicants here undergo qualifying training at the Justice Training Institute before being appointed as a JP. The Turks and Caicos has something similar. They have a Justice of the Peace No. 2 regulations of 2023, so it's a fairly recent development. And those JPs are also required to participate in professional development training, and these are like 2 sessions a year. There's proof of attendance required, and then disciplinary action if you don't participate, that kind of thing. Ontario, Canada, they have a very formal system. And then in the Bahamas, actually, just this year, they introduced a bill. It hasn't, I don't know if it's been debated as yet, but they have introduced a bill called the Justices of the Peace Bill 2025, which proposes things like mandatory training, and this training is accredited and approved by the Chief Justice as part of your appointment as a JP. And I would have heard Senator Al-Rawi, and it was mentioned among other speakers as well, discuss the Justices of the Peace Bill of 2023 drafted under his tenure. And I think that when I go on further, I think this is the kind of legislation that I'd hope we'd have the opportunity as a Senate to also ventilate, to discuss, and bring to the fore. Now, the invasion of, and I want to break this down because we've had quite a few lawyers speak on the topic, but I want to break it down a little bit more, especially for those who are not legally trained and who might be listening in. The invasion of a person's home, your business place, your vehicle, your shop, your private places, for that matter, is a significant constitutional infringement. And the thing is, such an infringement should only be permitted where there is enough evidence and there's reasonable justification. Naturally, because of what the intrusion entails, there's a high degree of protection that's warranted. And it is the belief that the approach which best enforces these protections demand the empowerment of legally trained persons to perform these duties. And I know that Senator Allahar would have mentioned, you know, if there's procedural irregularities or if there's a challenge to the validity of a warrant that was issued, there's always the opportunity to appeal. But I believe, why should we, if we have the opportunity to do differently and to do better, why would we permit the misapplication or the inapplication of justice when we could just prevent it in the first place, when there are certain safeguards that we can put in place in the first place to maybe mitigate the occurrences of that happening? And I know that I would have heard in the other place, no, actually it was here, the Attorney General wondered in a very light way, because it's a good debate, he wondered, you know, if the then government, back in 2023 when these amendments were made, he wondered if it is that the government then just didn't like JPs. And I think it's not that the government then didn't like JPs. It's just that no one really likes the intrusion that comes from having their personal spaces and their personal effects searched. And in the interest of justice, it must be done is And in the interest of justice, it has to be done is a necessary ill. However, when it's done, we need to be satisfied that the necessary conditions have been met with enough evidence and that has been reviewed with the judicial diligence that the Attorney General, you also mentioned judicial diligence, right? The judicial diligence that he spoke about this morning. And I remember him mentioning that judicial diligence does not have to be restricted to judicial officers. So when that was mentioned, I sort of trained my mind to what such an exercise should look like, meaning the exercise of judicial diligence. And the first place I consulted was the same Central Broadcasting Services Limited case. And I looked at paragraph 26 of that case, where Justice Budasin said, a proper judicial process must be followed in the obtaining of a search warrant. Certain stringent criteria must be satisfied. Any incursion on the rights of the citizen must be carefully measured and be proportionate to the circumstances. There is no one-fit-all stipulation. There are, however, certain basic criteria that must be established. The process of issuing a search warrant is not a formality, and it must be subject to careful judicial scrutiny. I then consulted an even older case, which I believe is quite dispositive, and this is a 1997 English case, and I'll cite it properly, but it's AG versus Williams. And Lord Huffman really ate when he said this. He said, the purpose of the requirement that a warrant be issued by a justice is to interpose the protection of a judicial decision between the citizen and the power of the state. If the legislature has decided in the public interest that in particular circumstances it is right to authorize a policeman or other executive officer of the state to enter upon a person's premises, search his belongings, and seize his goods, the function of the justice is to satisfy himself that the prescribed circumstances exist. And the gist of it is this. This is the duty of high constitutional importance. The law relies upon the independent scrutiny of the judiciary to protect the citizen against the excesses which would inevitably flow from allowing an executive officer to decide for himself whether the conditions under which he is permitted to enter upon private property have been met. The independent scrutiny of the judiciary. And for me, herein lies the problem. I am not convinced that, as it stands currently, a justice of the peace issuing a search warrant, that they rise to the level of independent judicial scrutiny that should attach to the intrusion of a person's constitutional right to privacy. And as a matter of fact, just this morning, I was on the way here, I was speaking to a colleague, and he said, you know, while they're debating today, and I kind of very roughly, he's not an attorney, but I roughly explained it to him. And then he laughed and he said, so you mean so-and-so could give police search warrant? I wouldn't call the name, but the so-and-so was a JP that he referenced. And then he laughed again, and I thought to myself, this is reflective of the public's general apprehension. I mean, the public feels it and they knows it. And at the expense and at the risk of being misquoted, we have to ask ourselves, our justices of the peace, our JPs in their current state, are they qualified, trained, and equipped to wield such a power to authorize constitutional infringements and personal intrusions? Our JPs trained to engage the sort of balancing exercise that you need to carry out to determine whether or not a warrant is proportionate to the evidence that they have in front of them? Now, Senator Chote highlighted her concerns about the conduct, the status, and the conditions of some JPs. She also spoke about the need for greater accountability and reporting as pertains to our JPs. And then she also asked the question about what disciplinary action currently can be taken against JPs who might misbehave in their roles. Now, in the other place, when similar arguments were raised, it was described by the government as being elitist. But the question that I ask, Mr. President, to each and every single member here today is it elitist to respect, enforce, and advocate in favor of the protection of the constitutional rights of our fellow citizens? Do we not all have a responsibility to be robust in our enforcement of democratic principles? You see, in this particular matter, there's a very thin line between despotism and expediency, and we have to be very careful not to end up on the wrong side of it. Again, at the risk of being misconstrued, the reality is that with these amendments, what we take the chance of seeing is that any police officer with any sort of agenda might be able to pull up by a JP, suspecting or unsuspecting JP, and either bribe, force, or hoodwink the JP into signing a warrant so that the officer could carry out whatever action that they please. Now, this might not always be the case, but it is often the case, maybe too often. And again, yes, and again, that's why I said at the risk of being misconstrued, because I heard you speak, Senator Allahar, and you would have misconstrued my colleague, Senator Al-Rawi. I sat here and I did not hear him call JP's drunkards. He referred to one instance where something happened. And all of us practicing in the legal field, we've seen these instances. It's not a blanket statement about JPs, but these are observations, and we shouldn't. No. It has been expressed by various persons across the bench.
Senator, let's avoid the crosstalk, please. Continue.
Thank you for your protection, Mr. President. Nonetheless, the Hansard would reflect accurately what was said despite any sort of attempts here to disparage or to misconstrue anyone. We have to be very realistic about the society we live in. Trinidad and Tobago is definitely a beautiful place. It's one of the best places on the face of this earth. But it is also is a small place. And it's a very closely integrated, and Tobago smaller. Exactly. So, and I could speak even from that perspective. In Tobago, for instance, it's a small place, it's very closely integrated, everybody good with everybody. So sometimes there's a room for a bit of, what we want to call a little bit of mischief happens. So it's up to us to ensure that when we legislate in here, we take into account all these sorts of mischiefs that are possible, and that we implement the kind of safeguards that's required to deal with the intricacies and the nuances that are inherent in our norms and culture. I also had a look at a case that was brought by Justice C. Prasad. I think I would have quoted the case before. No, I didn't cite it before. One Caribbean Media and Others versus the Attorney General, 2021 case. And Justice C. Prasad, in reviewing the validity of several search warrants issued by a JP, he made the observation. He himself recognized the mischief that can be inherent in the current setup in the setup that we then had that the government is now trying to reinstitute. And he said there were evident errors on the face of the warrants. He was speaking about the warrants that were issued by the JP. And these errors were seemingly not detected by the Justice of the Peace. He then went on to advise that given there is currently no requirement for justices of the peace to be legally trained, they may generally lack the degree of specialization required to equip and empower them to deal with important constitutional issues, and the law should be reviewed so as to mandate the involvement of a magistrate or a judge. Now, this ruling was made in 2021, and this was just shortly before the 2023 amendments were passed. The amendments weren't done on a whim. They were done to mitigate a very real problem, a problem that attorneys recognize, a problem that defendants recognize, and a problem that even the court themselves recognize. And that problem continues to exist. Notwithstanding this, I do hear and I do understand and connect with the concerns that the Attorney General have raised here. I think we can all agree that we came here in the spirit of cooperation. Everyone's been trying to make this thing happen and to make it happen well. So my contribution to here today is not just based on, and it shouldn't be looked at just based on critique, but I want to also be constructive, because I believe we have to strike a balance between the efficiency that our police service wants to achieve and then the protection of the rights of our citizens. So how do we do that? And I have two suggestions, and they aren't novel. They're suggestions that were already raised by both the opposition bench and also by the independent bench. The first one, actually, Senators Al-Rawi and Senator Chote went into details about this in terms of reforms, in terms of the eligibility criteria, ongoing training, reporting obligations, disciplinary actions, and regulation of justices of the peace. Now, in addressing it, I would have heard Senator Allahar indicated the government's intention to increase the training that's going to be available to justices of the peace. I would have heard Senator Al-Rawi mention the Justices of the Peace Bill 2023 that is currently sat in the Office of the Attorney General. I had a glance at that bill during lunch, and it seems like it provides guidelines for the appointment of justices of the peace, as well as for the tenure, the removal of JPs. It also establishes a disciplinary committee and a system for carrying out disciplinary proceedings. And then there's the establishment of an advisory board. There seems to be quite a bit of work in that bill that addresses a lot of the concerns that have been raised here. I know that Senator Chote also spoke about legislation that was drafted even well prior to this, maybe 2007. I haven't had a chance to look at this. My recommendation, however, to the government is that we take a very close... Mr. President, I'm trying to make a contribution, and we have people over there acting like children.
No, well, please. We don't refer to senators in that way. But I agree that there's a running commentary on my immediate right. I am getting some difficulty in listening and following. So can I ask my colleagues on the right to allow the Honorable Senator to speak in silence? Continue, Honorable Senator.
Thank you, Mr. President, and I retract the bit about children. But what I was saying is that we've had recommendations from both the independent benches and from the opposition bench with regards to bills that were drafted that address some of these very real considerations. I think that in addition to the training that the government intends to implement, my recommendation is that we take a look at these bills in its entirety and also implement or bring before the Senate some of the other issues that they address with regards to the tenure, removal, disciplinary proceedings, reporting obligations, and that sort of thing. So we have a more comprehensive reform then of the JP framework within Trinidad and Tobago. And then the second recommendation I have would have been mentioned by Senator Dr. Murray, and that was to go a bit further, to collaborate with the Chief Justice in such a way that allows for the assignment of additional emergency masters. And these masters, the idea is that they will handle whatever additional applications that we're getting outside of normal court orders. If the concern here is the efficiency with which these warrants are being issued or considered, the applications are being considered, and I think that this is also a very feasible thing to have done, especially in the interim while we look into maybe supplementing or training up our JPs as well. And I guess it will be ventilated and the government will be able to give us additional information on the feasibility of that. But I think there's no shortage of maybe qualified attorneys who would happily take up the mantle to operate in the function of masters of the court and carry out these emergency applications. And I think this isn't a novel undertaking. I looked at a few jurisdictions who also have something similar in place. The U.S. federal and state courts, they do it right now. They call it an on-call duty magistrate judge system. And then we have in the UK as well, they have an out-of-hours rota, and they call them duty magistrates. In Australia, a few other jurisdictions have it as well. So this is something that's feasible, and as I said, while we sort of look towards bringing back a bill that addresses how we deal with justices of the peace, I think that this is a nice sort of mitigating step that we could take to address this issue that the government has brought before us. Now, Mr. President, I'm pretty much finished. As I would have started, this debate is not a contentious one. I think that all of us here understand what we're trying to bring to the fore and what we're trying to get done, and we all want the outcome that the Attorney General is advocating for. We just need to ensure that the means by which we're doing it actually justifies the end. So I do hope that all that's been said will be taken on board and that we'll see the government take even an additional step or two towards making some of these recommendations a reality. Thank you, Mr. President.
Senator John Heath.
President, for the opportunity to contribute to this debate. Mr. President, very early in his contribution, the Honorable Attorney General stated that the amendment seeks to find the balance between investigative efficiency and constitutional rights. And I suppose that is always the task for any government. And oftentimes, stakeholders may be aggrieved, one or the other, simply because they may find that the appropriate balance has not been struck. But in any event, these are realities that the government must address. So, dealing first with the issue of bail, which I think is the one that has found immediate consensus. First of all, I have to commend the Honorable Attorney General for seeking to codify that which the case of Joel Alexander expounded upon. I suppose it may have been easy to say, well, we are not going to appeal and leave it at that. But it's important nonetheless to codify so that our laws come in line with the case law. If only, Mr. President, for the fact that it seems that
Yes, one second, Senator. Colleagues, I don't want to I'm trying to avoid creating unnecessary statics, but it is becoming extremely difficult to understand why we continue to ignore rulings. And we even circulated a procedural note concerning the use and the abuse of mobile phones in the chamber. It is disrespectful, it is contemptuous on the part of senators who repeatedly ignore rulings and the procedural notes. I don't want to reach a point where we have to ban cell phones from this chamber. But if you all push the chair to doing that, it will be considered. I'm asking members again, keep your phones on silent. That is what I'm asking people to do. Senators, that is. Why continue to flout, ignore, disrespect, show contempt and contumely? Why? Please, don't allow the chair to rise again on this matter. I've spoken on it repeatedly. Sorry for the interruption, Senator Heath.
Mr. President, I was saying it is important to bring in line legislation which falls in line with judgments which stand, as is in the case of Joel Alexander. And I was saying if only because, certainly it is my experience that legislation seems to reach the Trinidad and Tobago Police Service a lot faster than judgments of the court. So what has happened here, you've saved a lot of attorneys at law of going into stations, seeking bail for persons on indictable offenses and having to walk with Joe Alexander judgment. And I'm reminded of the case of Frankie Boudram, which is now 25 years old, and the useful dicta of the Court of Appeal that police officers ought to make contemporaneous notes in their pocket diaries. And to this day, there are police officers who do not know about that judgment, do not make the necessary notes, and cases fall apart because of it. So the Honorable Attorney General is to be commended for seeking to bring in line the legislation with the case law. Now, having said that, prior to the judgment of Joel Alexander, a lot of persons would have suffered simply because they could not get bail for matters which were laid indictably, but really were not serious. And Joel Alexander is the perfect example, because he was charged with obscene language and resisting arrest. And resisting arrest is an indictable offense. Invariably, that matter will always, the prosecution will always recommend summary trial, and it will always be tried summarily. Even if found guilty, a person with no priors is not likely to serve custodial sentence. But in the case of Joel Alexander, he spent more than 48 hours in custody, so that the judgment was welcome, and now the legislation to treat with it and bring it in line is equally welcome. Now that deals with the issue of bail, which I fully support and endorse. The other issue is the issue of the search warrant. Now, first, let me say I too had some concerns, which Senior Counsel Chote and Senator Al-Rawi expressed, and Dr. Murray, I believe. But I was glad to hear Senator Allahar, even before the debate has wrapped up, with some mature considerations to try to alleviate those concerns. But let me also say this. The issue I had with the JPs is not limited, as it were, to the issue of search warrant. Indeed, in matters of bail as well, I have concerns with justice of the peace. Now, in this instance, in the proposed amendment, their function is circumscribed because they cannot grant bail in circumstances where they're required to show sufficient cause or exceptional circumstances. So those are the serious offenses. So that is good, because one could well imagine if that was unfettered, you would have persons who are charged with serious crimes, who the evidence is quite good, may be granted bail, and never turn up to court. So let me say my concern was also with the bail. This is why I was glad to hear from Senator Allahar that, first of all, that there will be training, because I am certainly not in a position to say that they cannot, being the justice of the peace, cannot be trained. And I suppose they will be trained by persons who perform these functions, such as judges and other like personnel who would give the required training. So when they are approached for warrants, they would ask the proper questions. But I was perhaps even more elated when Senator Allahar indicated that there will be a proclamation clause which will ensure that the training takes place before the law comes in force. So that, as I understand it, if there's a training, but a particular JP did not attend that training, then he or she will not be able to issue a search warrant. I give it.
Mr. President, I hope this doesn't affect my learned friend's elation. But the indication I gave with respect to training, well, training is general, but the proclamation clause has to do with the search warrants. We can't do it with respect to the clarification of the law, because the learned judge has declared the law already with respect to the bail. But that proclamation clause will be in respect to that part dealing with the search warrants. Yeah. Okay,
yes.
Thank you.
Yes, so my elation remains in place, Mr. President. Yes, that is what I understood, because I certainly see that there's need for training with respect to that, and ongoing training, so it's not a one-off thing. What had concerned me, of course, is that under the Section 5, and I must confess that the concern is not only with the JP, I had concerns even with the master, and I think Senator Chote alluded to it, the type of expansive powers with respect to searches that could be given under Section 5. So I was happy when Senator Allahar indicated with respect to 1B, which states, and this is 1B of JIPA, a search warrant may authorize the search of premises on more than one occasion if the master is satisfied that it is necessary to authorize multiple searches in order to achieve the purpose for which the search warrant is issued, and such search warrant shall be valid for such periods as may be specified in the search warrant. I do find that to be a bit draconian, even for a master. So that to hear that what is being proposed now is that the old common law powers with respect to justice of the peace granting search warrants will be limited as it will before is welcomed. So all in all, I'm happy that there has been some consideration with respect to what has been the contributions made by the independent and opposition bench, and I think certainly the further of this debate is heading off in the right direction. Much obliged.
Senator Anthony Vieira, are you speaking? Oh, Senator Francis Lewis.
Thank you, Mr. President. Thank you, colleagues. My presentation will be short, and it comes in a different direction. And I am hoping, Leader of Government Business, when we come to committee stage, some of these questions that I'll be asking may be addressed. Some have already been started to be addressed, but I still have questions. In looking at this, I come to this not as a lawyer. I'm coming to this saying, what is this solution intended to achieve? And my starting point was to try and understand the justice system of Trinidad and Tobago. I'll share the numbers that I was able to glean. If these numbers are wrong, I apologize, and please do correct me. We have about 32 magistrates, 8 registrars, 37 masters of the court. The last number I could find for JPs was a December 23 number of 138. High Court judges, 44. Justices of Appeal, 15. Multiple other functionaries. And from statistics I saw, the indictable matters for 10 years, 2012 to 2022, was 88,350. So that roughly is about 8,000 to 9,000 matters a year. If I start with those numbers, even if hopefully they're not massively wrong, then the system has a built-in capacity to deal with a number of matters. And in the appropriations bill that we considered a couple of weeks ago, we said, okay, this is the money we're spending as a country and as a society to be able to deal with it. It seems to me, in looking at this act that was passed, the AJIPA, since 2011, there have been multiple adjustments. And forgive me if I characterize this poorly, but considerable flip-flopping in determining which functionaries are given concurrent jurisdiction and in what matters. And so it's going back and forth. I'm not saying that those changes were necessarily bad. I'm just saying it seems to be a lot for something that needs to be settled. So out of this came 4 broad sets of questions. There appears to have been a significant amount of tinkering with this. And what struck me is the question, what is wrong with how the present law is working? Because if you make a change, and I'm not against improving things as we go, because sometimes that's what you need to do, but it seems to be a lot of changes. And there are consequences to that. What is the mischief or the deficiency that the changes are trying to correct? What informs the changes? And ultimately, what is it we're not getting right? Maybe we have gotten it right on this occasion, but I don't know. And given all the changes before, the level of confidence that we have gotten it right this time is not terribly high. And that's not a negative commentary. It's just an observation over a period of time. A larger question is, what is the capacity we're trying to build into the system? If the system has to deal with a certain number of matters a year, whether it's murder rates, whether it's indictable offenses, the system has to be able to deal with it. And we hear, I don't have a number for this, but backlogs are considerable. Or that's the sense that I have, that matters take too long. Therefore, you need a system that can handle the volume of work required. And in the context of that, when we give and remove authority, and then we give again, it creates a confusion or potential confusion. And here I'm very deliberately speaking, Mr. President, not as a lawyer, but as a layman, looking at this and saying, but it has to make sense. And going back and forth does not increase my level of confidence. And I have a very high level of confidence in the justice system of Trinidad and Tobago, but I don't want that to be eroded. So if we're going back and forth, giving officers, various authorities, do the officers that we've named have the training and support for the duties and responsibilities they're given? And beyond that, because all of us have been part of training programs where attendance becomes the measure of the training. It's really a measure of activity. It's not a measure of competence. So how can we be sure that there is a reasonable qualification that the officers that are given authority have not just the knowledge, but the background to be able to apply it? And how do we verify that? So my second question has to do with, how do we address the capacity to build the system? The third question has to do with, what were the consultations done? I heard in the earlier debate that at some points significant consultation was done. I'm not sure that when I looked at the information brief for this particular amendment, it didn't speak to what consultations were done. And maybe all it requires is, it's not working, let's try this. But various associations, whether it's the criminal bar, whether it's the Bar Association of Tobago, will have a point of view. And I don't want to gum up how quickly one gets things done. But if we're going back and forth with changes, it suggests that somebody is missing in the consultation, and then we catch it, and then down the road we try and make another change and another change. In all of this, I want to say to the government, I'm not at all averse to improving legislation. But repeated tinkering creates confusion. It creates confusion in the profession, because at some point, officers have a power, then they don't have a power, and we're not sure what jurisdiction they're working under. And to the practitioners in the field, I'm sure that, yes, there's a responsibility for ongoing education. But even so, that makes an assumption that we don't have to re-examine every single last thing every time we go to court. And to the man in the street, people like myself, it's kind of like, it sounds very confusing. So while one wants progress and change, you also want a level of predictability, and you certainly don't want confusion. So changes like this have consequences. And it occurred to me that the solutions have to work and not add to the problem. A number that I would love to get, I have not been able to find, is if I look at the court system in Trinidad and Tobago and I look at the backlog in the system, what percent of that backlog is trying to deal with matters that should not have taken place in the first place? So you're cleaning up. And to say, well, we will give the authority, but we have the power of review by a higher court or higher jurisdictional body, is a very expensive way of quality control. Is there not a better way, I would wonder. I'm not sure in the presentation by the AG that I understood how wide the impact of this change is likely to be. And ultimately, what assurances might there be that it will address the mischief or the deficiencies that it is itself trying to correct? So given the multiple changes, I'm really looking for, as much as one can, Mr. AG, any assurances that you might reasonably be able to give that amending this amendment bill will in fact remedy not just the mischief, but hopefully make this system more efficient. I wish I could make prescriptions. What I ended up with more questions than, and perhaps that's just my own ignorance of the field. But with that, I thank you, Mr. President.
Senator Janelle Bates.
Thank you, Mr. President, for this opportunity to join in this debate. Mr. President, the issue has been canvassed almost thoroughly throughout this day. We have heard from many speakers on this topic as to what we're here to debate today, the restoration of the concurrent jurisdiction of Justice of the Peace with masters, the magistracy registrars, and a clerk of the peace to issue search warrants, and also to give them or grant them that power to grant bail in certain circumstances. And we, the opposition, have already made our position clear on this debate. We do not have any reservations in supporting the Justice of the Peace having the ability to grant bail, and we understand the position of the government in relation to that being a necessity to avoid any paralysis in the system because of delay. But we still have concerns and reservations as it relates to search warrants. We see restoring that concurrent jurisdiction as a regressive step. We do not believe that conferring that power in serious criminal matters in particular would promote justice, fairness, or the protection of citizens' constitutional rights. The mischief as identified, which is the delay in allowing citizens to, the delay that was pointed out by the government, there are alternative remedies to cure that mischief. And some have been expounded on already for the day, so I won't delve into them, but I would suggest two others that I have not heard by anyone else. Now, at the beginning of his contribution, Senator the Honorable Jeremie indicated that in the first time that this was debated, this concept of removing the powers from the Justice of the Peace to issue a search warrant, there was no rationale given. He could find none in the Hansard. But I also scored the Hansard, and I could find no opposition to the concept. No one identified any issue with it back then. But be that as it may, today we have heard the rationale. We have heard many grounds, many reasons for concerns posited by both the opposition and the independent bench. I would identify them as the paucity of legal qualifications of the Justice of the Peace, the risk of corruption and lack of accountability. This one wasn't quite expounded on, but I will touch on it, the expansion of executive reach, and also the modern risk posed by search warrants in a digital age. I don't know if anyone has really thought about that. Now, when some of these concerns were raised, Senator Allahar sought to assert that we're casting JPs as villains. It's not a matter of casting JPs as villains. It's about recognizing a reality, an everyday reality that is obvious to those who are very, very much involved in the criminal justice system. It is about raising these concerns so they can be addressed, and I'm happy that Senator Allahar did bring he did make some attempts to address the concerns raised, but I would indicate some of the weaknesses of what he would have indicated. Now, as it is for the paucity of the legal qualifications, we have heard it all today. JPs, they don't need LLBs, they don't need LEC, there's no need for judicial continuous training. In contrast to masters who have and magistrates who have LLBs, LECs, masters require 7 years of experience. We've heard why all those things are required. Those things are required in a case where a justice of a peace has to issue or grant a search warrant, because before they do that, they have to cast their mind onto a very important principle. They have to ask themselves, is there reasonable grounds for suspecting? Have the police brought to me anything that would show a reasonable ground for suspecting that you can find some sort of evidence in the place that they want to search? As was said by Senator Jeremie, this requires judicial diligence. It requires constitutional awareness. These are rigorous standards. So I don't want to beat that dead horse again about training. But I did hear Senator John Heath indicate that he did have some reservations as it related to bail. He gave the example of perhaps someone with a strong case going for bail, be released on bail, and basically never returning for the trial. Now, he didn't go quite as far, but what I gathered from him is that he would have some concern as it relates to the JP's ability also to grant bail because of a lack of training or perhaps a dearth in their knowledge. And again, I would want to point out, when a JP has to grant bail, this too is a very important function. It's not something clerical. They have to assess flight risk, the possibility of the person who's seeking bail reoffending. They have to consider whether they would interfere with witnesses, the seriousness of the offense, the character and antecedents of the accused, their social ties. So there are many things that they would have to bear in mind to, which require that training that it does not appear that they have to prove that they have before they are given that function. Be that as it may, because of the safeguards within the Act, we do not oppose the restoration of their power as it relates to bail. But I just wanted to point out, I understand some of the concerns that I believe Senator Heath would have alluded to. Because the simple issue, coming back to the issue of grant and search warrants, is this. It has been said time and time again, because of perhaps the lack of training, JPs have become rubber stamps. That term rubber stamps has been used in many cases. Whatever the police tell them, stamp, done. They agree. They don't, again, cast their mind as they're required to. Now, in addressing that issue of training, Senator Allahar would have mentioned that there would be a proclamation clause in order to allow some training for the JPs before we move ahead with this. But I am not assuaged. My concerns are not assuaged because there were no specifics. We didn't hear who training, when training, how long, when this clause. So it just felt like it was said to allay fears or try to smooth over any concerns we have without really addressing or being a serious policy that the government will pursue. I am not convinced. Now, the other concern that was mentioned already as it relates to JPs is the risk of corruption and the lack of accountability. And Senator Chote really drove home that lack of accountability. But I just want to, again, put it in another context. JPs currently, they're not paid. This is a voluntary rule. They get a meager honorarium of $1,000 per month. Along with the lack of accountability that Senator Chote would have driven home, that really leaves them vulnerable to corruption. We have heard, if you're an attorney practicing in the criminal arena, you would have heard about facilitation fees, tanks. In fact, recently, a senior practitioner at the bar gave me an anecdotal a story or a case he had with a client. His client, a pilot, found himself in an unfortunate circumstance where he was charged in relation to a firearm. The police informed him that, yes, the JP will come, give him bail for $50,000. However, he has to give the JP $5,000. This is yet another example of how we have some unscrupulous behavior. The example given by Senator Al-Rawi was in relation to being drunk. We have already heard Senator Chote spoke about that unfortunate incident with the ill JP where the police tricked him and used the stamp. These JPs are vulnerable for various reasons to be corrupted, and in this case, it's because of the meager honorarium. Now, I am not saying that they should necessarily be paid a salary because their role is a community service. But we need to be realistic about the difference between what a JP receives as remuneration and what a master and a magistrate, for example, receives. A master, by contrast, is paid base salaries $37,335, and a magistrate's base salary is $33,931. This is public knowledge. This is in the 120th Salary Reviews Commission report, and that's the base salary. So someone receiving that, and along with the other circumstances as to how they operate, I'll get into that, they are less likely to be susceptible to bribes, payments, and fees. When we put that situation of the meager honorarium, then we added to the lack of oversight, the lack of the disciplinary tribunal that was already spoken about, the lack of a statutory code. When a JP breaches their oath, what recourse does a citizen have? Challenge the warrant in court? As it was already said by another senator, that requires funds. And if you don't have the funds to do that, where are you left? In the case of Brent Thomas, the judge found that the JP acted as a rubber stamp, that term I raised before, and he commended the case to the Justice of the Peace Association of Trinidad and Tobago for its consideration and for such action as is appropriate in the circumstances. What action? Mr. President, I've heard no action. I don't even know what can the Justice of a Peace Association do if one of their members breaks the law. They take a serious oath, Mr. President, to bear true faith and allegiance to Trinidad and Tobago, uphold the Constitution and the law, to act conscientiously and impartially, and to the best of their knowledge. A beautiful oath, I'm sure they were sincere, but without any enforcement, it is just symbolic. Again, we have to contrast that with a master magistrate. These individuals are subject to the Judicial and Legal Services Commission. There are guidelines, there's recourse, there's discipline if they breach their oath. Now, the Minister of Legal Affairs in the other place, again, allay our fears by indicating that there was an interministerial committee set up to address some of these concerns and they already met. But the fact of the matter is, if they have met, there has been no report emanating from that committee. We do not know what they have recommended. So to expand the powers of a JP without any reform in their training, their discipline and remuneration is basically to invite abuse. Now, this risk of corruption that I would have spoken about is compounded by the fact that JPs, again, they have further exposure to interference, pressure, and danger. JPs operate in the communities, in shops, one-man shops sometimes. They operate a lot out of the police station because of what they inquire to do. Some of the duties of the JPs include authenticating witnesses, witness statements, attending ID parades, the station bail, so they are amongst the police a lot. This easy access that you have to them, day and night, shop, police station, etc., actually exposes them to intimidation by criminal elements, pressure by the police, trickery, for example, of the type elaborated on by Senator Chote. Then there's the over-familiarity with the police officers, coercion by families or the communities. That is they operate in a totally different sphere, again, from masters, magistrates, and the like. And that, again, there's another level to it. Political pressure, please, Mr. President. The fact of the matter is JPs are executive appointees. They make we have heard before, they send in an application letter, it goes to the relevant minister. Yes, they are appointed by the president, but it's on the advice of the minister / the cabinet. We've heard that. So again now, this bill here is allowing us to re-expand, if we should say, their reach into the domain of indictable matters, serious matters. We're talking about murder, human trafficking, terrorism, financial crime, the most serious matters with the highest penalties. So we are basically authorizing executive appointees to make decisions that permit police officers to enter your private home, seize your digital devices and sensitive data. On whose behest? On whose behest? There have been several reported cases where it has been alleged that the granting of search warrants was influenced by political considerations. And in some of these matters, the courts have actually found that there was an improper exercise of discretion. We have to recognize that we are not only legislating for the government of today, though I would be wary about that as well. We must legislate for any government, present and the future, to ensure that these powers cannot be misused, that an executive appointee can't be used by someone else for their own agenda. Previous amendments to JIPA
in previous amendments, Parliament deliberately placed protection of liberty and privacy in the hands of independent judicial officers appointed, as I said before, by the Judicial and Legal Service Commissions. These officers are insulated from political influence. Now, I mentioned something earlier, the modern side of search warrants. Now, Senator Chote would have spoken about the draconian nature of search warrants as contained in a JIPA. Senator Al-Rawi also spoke about it. He talked about the wide and roving warrants. I think Senator Chote also spoke about it, that it's not confined to one premises and it's not limited in time. So we understand that side of the broad nature of the search warrants that we are speaking about. But we also have to think about search warrants in a modern context. Most times when we think about search warrants, we think about police officers kicking in doors and riffling through cupboards. The house turn up is a mess like a hurricane. But modern search warrants also allow the police to comb through your phone, your email, your cloud storage, your servers, your encrypted messages. In the same Brent Thomas case, the warrant authorized seizure of cell phones, including SIM cards, SD cards, images, calendars, phone books, contacts, SMS messages, emails, pictures, videos, audios, files, call logs, installed application data, voice recording, voice messages, GPS information, Wi-Fi information, internet history, user files, system files, computers, tablets, external storage devices, digital video recorders, network video recorders, and any other data containing aforementioned electronic digital device included unallocated space. That is extensive, Mr. President. Some people here don't even want their husbands and wives to hold their phone. You want the police to have access to your private messages, your financial data, your health records, your location? Mr. President, we have to think about it. That is why these powers, the power to issue that sort of what has been called a grave and extraordinary power, has been situated by previous amendments in the hands of trained personnel who again can cast their minds and ask the relevant questions to come to a conclusion that there are reasonable grounds for suspecting that the evidence is where the police say they can find it and would not just, as we say, rubber stamp and allow the police to go searching here, there, and anywhere, please. We have to start thinking about legislating for a digital world and not a paper world, please. Now, the Attorney General said we had the power before. We are simply restoring it. But there are many things we did before that we should not do again. Child marriage was once illegal. We don't want to go back there. The power was removed precisely because it was abused. And it's not about casting any aspersions, calling anybody villains. It's about recognizing reality. Untrained and underpaid JPs can issue warrants on weak grounds. It's as simple as that. A warrant, as I said, often literally authorizes the police to kick in your door. But it is the JPs who are giving them the metaphorical boot to do that. We have to be careful about who we are giving these boots to. Now, let me just come quickly to the solutions. Because the opposition does not dismiss the operational concerns of the law enforcement. We understand. Sometimes getting evidence is very time sensitive. Especially, as I said, we're in a digital age. We need the phones and we need them quickly. We also are not dismissive as it relates to the powers of the JP in bail, to the plight of those who are unable to access bail in a timely manner. And before I go on, I want to just mention something about the case of Joel Alexander that was discussed by various speakers today. As was said before, he was charged with obscene language and resisting the officer, resisting arrest. And that charge of resisting arrest was laid indictably, and he was informed, the JP said, yeah, we can't give you bail, we no longer have that power in indictable matters. But the issue here, what happened in the end is that he spent 57 hours in what was described as subhumane conditions, speaking about how he had to relieve himself in a hole in the ground in a police station. The evidence was something to read. Very unfortunate. However, the root cause of him remaining in that prison or that police station for that length of time really was not because there were no JPs. He was arrested on the 17th. The JP said, no, I'm not coming. He was supposed to be brought the very next day, the 18th.
However, what is required, or what was the policy, or is the policy of the police, is that his complaint needed to be uploaded by 10 a.m. The police did not upload his complaint by 10 a.m. And when his attorney called to find out what happened, the police officer was like, it's 10 a.m., I have a meeting at the waterfront for 1 p.m. We cannot upload the document. And that was the 18th. The 19th was Labor Day holiday. And then he was brought on the 20th. So it wasn't a matter that they couldn't get a master on the 18th to hear his matter. It was really about administrative delay. And it's about basically an indifference. The police officers exercise an indifference. We didn't upload it at 10 and too bad. So really and truly, is it about getting more JPs or addressing other inefficiencies in the system? So that's why I come to my two solutions here. So we would have heard about, because I had 4, and 2 of them already mentioned. I have it here, established after hours or emergency master roster. I know that it can be done because there's an emergency roster for judges, there's an emergency roster for assistant registrars, and I am almost 100% sure there's already currently one for masters, but maybe they don't treat with bail, I don't know. So, well, I'm hearing that they do. So that has already been spoken about. We've heard about reform of the training, appointment, and discipline of JPs. That has been spoken to. But I have 2 additional suggestions. What about just expanding the pool of trained personnel, the masters and the magistrates? And you may say, that sounds easier said than done. In 2024, there was produced a merit list of trained individuals who are qualified to be masters, as in who have been selected to be masters. The merit list is still active. There are at least 14 individuals, I know for sure, who are still on that merit list. Therefore, at least some of them are still waiting to can be called tomorrow to be a master. 14 people on the merit. So we don't have to go through any interview process, because that process is a very long process to become a master. You have to go through an exam, submit portions of your work, then an interview and a psychometric test. All of that has been done. We have the list of individuals. Hire them. Then I know we also in the process of creating the merit list for magistrates. They have already reached the psychometric test phase. So essentially, I would say within a week, if not already, they should already have the merit list for magistrates. So instead of trying to expand the power of the JPs, hire more trained judicial minds to do the job. So I would say the solution is about greater judicial capacity and not weaker judicial integrity. I would say that the issuance of search warrants is not an administrative convenience, especially as it relates to indictable matters. It's a matter of a high constitutional importance. We have been talking about delay today, but fast justice is often, or not always, fair justice. So we are calling on the government to strengthen judicial capacity, not dilute judicial protection. Yes, the police may need more speed, but the people deserve safety. And that safety is also not from criminals alone, but from careless lawmaking. Thank you.
Vieira.
I would like to foreshadow my contribution with a couple broad observations. In every democratic society, the making of criminal justice law demands the careful balancing of competing but complementary ideals. On the one hand, the Constitution enshrines the right to liberty, the presumption of innocence, and the entitlement to reasonable bail. And on the other hand, the state bears a solemn duty to maintain order and to protect the public from crime, especially dangerous criminals and repeat offenders who have been apprehended by law enforcement. These are not opposing forces. They are two halves of the same constitutional whole. The difficulty lies in maintaining proportion, ensuring that public protection does not come at the expense of fundamental justice, and that the preservation of liberty does not erode public safety. We've heard a lot about Hines, and as the Privy Council pointed out in that case, legislative power in a constitutional democracy must always be exercised in harmony with the rule of law and judicial independence. Having said that, I think it's also useful to put this bill into context, because it comes in the wake of discontinuing one system and replacing it with another. And transitioning between systems must be handled very carefully and sensitively, especially when they touch on fundamental rights and freedoms. Specifically, the right to liberty and security of the person, guaranteed protection of the law, the presumption of innocence, the right to reasonable bail, and the right not to be deprived of such procedural provisions as are necessary for the purpose of giving effect to the protection of those same fundamental rights and freedoms. A JIPA was enacted to abolish preliminary inquiries and to introduce a new pretrial regime centered on sufficiency hearings before masters of the High Court. And 14 years on, it continues to evolve. The bill before us today is the latest refinement. The bill before us, I dare say, is a direct response to the judgment of the Honorable Madam Justice Carol Gobin, as we have heard in the Joel Alexander case. Now, in that case, in that judgment, the court identified a critical lacuna in Section 10 of a JIPA. The court held that Parliament did not expressly remove the jurisdiction of justices of the peace to grant station bail in indictable matters, and that any such deprivation could not be achieved by implication. Now, when I saw this bill in its original form, prior to the Honorable Attorney General's proposed amendments, I was concerned that instead of vindicating the constitutional values highlighted by Madam Justice Gobin, we were going to codify the very policy the court found inconsistent with those values, taking what was either a misinformed or illegal position and making it law. That is to say, removing the power of the justices of the peace to grant station bail. So I was very happy when I saw the proposed amendments from the Honorable Attorney General, and I wish to thank him for eliminating the concerns I had regarding the initial bill, for bringing consistency in keeping with Madam Justice Gobin's judgment, and for codifying the power of JPs to grant station bail. And, Mr. President, I think I would also like to recognize and to place on record my personal, and I dare say the country's gratitude for Justice Gobin's comprehensive and compelling review of the common law and statutory authorities of justices of the peace to grant bail, for shining a light on this matter, the human consequences that can occur, and for triggering this debate. Now, you know, a lot of the times things look one way on paper, but when you read between the lines, they take on a life of their own. And reading between the lines, this bill raises fundamental issues and highlights challenges and constraints facing us as legislators, in particular, the careful balancing of competing interests, one of our most delicate and difficult responsibilities. On the subject of bail, on the one side stand the rights and freedoms guaranteed by the Constitution, the right to liberty, presumption of innocence, entitlement to reasonable bail. And on the other side, the state's legitimate ability to protect the public from crime, maintain order, and ensure that justice is both done and seen to be done. On the one side, the need to ensure that dangerous criminals and repeat offenders are kept contained. And on the other side, the duty to ensure that systems and mechanisms are in place for deserving persons to apply for bail within a system that is efficient, coherent, and constitutionally sound in accordance with our fundamental rights and freedoms. And as we have heard, Justice Gobin's decision illuminates the human cost of a faulty regime or system. Mr. Joel Alexander had been arrested for using obscene language and purportedly for resisting arrest. As we've heard, the latter was charged indictably. And he was detained for 57 hours, spanning a weekend on a public holiday, because no JP was permitted to grant bail. The conditions of his detention, unsanitary, overcrowded, and degrading amounting to a violation of his right to liberty and protection of the law. One constraint that really hasn't been discussed much in this debate, but I think is important to bear in mind too, is to remember that there is a separation of powers principle. The executive administers the country, the legislature makes the law, and the judiciary interprets and applies. Now, had the Attorney General not taken the decision to reinstate the power of JPs to grant bail via the proposed amendments, we would have had to rely on the judiciary to provide for roving or emergency masters, because the deployment and the control of those masters falls squarely within the remit and the purview of the judiciary, not us, not the executive. So there would have had to been some sort of discussion or liaising or coordination. On the issue of the search warrants, I didn't have an issue, as there is no substantial change in the law being made here. As we know, JPs derive their authority from the Summary Courts Act, Police Service Act, and the common law. And I was very happy when Senator Allahar alleviated my concerns when he spoke about wider JP reform, training, and that the powers of JPs would be limited to their common law and historical powers, as opposed to any expanded or extended jurisdiction. There are advantages to allowing JPs to issue search warrants. Some of these, well, JPs are geographically and practicably more accessible, especially after hours and in remote areas. Timely warrants, as we have heard, are vital. Delays can defeat the purpose of the search warrant because it gives a person an opportunity to destroy evidence or to hide evidence. So, empowering JPs reduces investigation bottlenecks and supports operation policing needs, especially as the judiciary cannot realistically provide 24/7 warrant coverage without special arrangements, for example, duty masters. Now, as we have heard, there are disadvantages. Unlike magistrates, JPs are laypersons with no legal training. The assessment of reasonable grounds, probable cause, and the sufficiency of a witness statement is a legally technical thing. JPs are not required to produce written reasons or to maintain a record comparable to a magistrate. And that makes ex post facto review a lot more difficult. But aggrieved persons have recourse. An improperly issued search warrant can be quashed at judicial review for all kinds of reasons: lack of reasonable grounds, insufficient evidence, excessive jurisdiction, bad faith, or failure to apply the correct test. And there are civil actions that you can bring in tort. Where a search is unlawful, the state may be liable for trespass to goods, trespass to property, conversion, malicious procurement of a search warrant. And High Court relief may include damages, declarations, and vindicatory awards. Evidence obtained under a defective warrant is liable to exclusion. And the JP can be reported to the Ministry of Legal Affairs for disciplinary action. So overall, I mean, again, there's always this delicate, difficult balancing exercise, but overall, I think accessibility, speed, geographical availability, and the support of continuing police operations, I would accept that those benefits outweigh the risks. I accept that there are risks and that training and oversight may be inadequate, but the courts have a robust supervisory jurisdiction and aggrieved persons have multiple forms of recourse. So for me, the issue is not legality, but whether safeguards are strong enough to ensure the constitutional proportionality and to prevent abuse. So in concluding, I would say it's generally accepted by lawyers that the AJIPA system is a vast improvement over the old system of preliminary inquiries. We don't want to make our systems and processes overly complex and convoluted. My concern in approaching this debate was to ensure that there was no conflict with any fundamental human rights, because those rights mean little if administrative delays and statutory restrictions cause persons charged with minor offenses like Joel Alexander to spend weekends in custody, suffering insanitary, overcrowded, degrading detention for minor offenses, conditions wholly disproportionate to the alleged wrongdoing. But happily, that is not the case. So, all in all, I thank you, Mr. President, and I will support this legislation.
The Honorable Attorney General.
Mr. President, this is a different type of afternoon. I don't think, since I have been here, that I have heard Senator Vieira speak without conditions in support of a measure. It's certainly one that I have. But I accept that as he ended his contribution, and I want to begin where he ended his contribution. He ended his contribution by saying that AJIPA is far superior to what we had before. We've abolished dual indictable proceedings legislation, and we've embraced a new culture. Now, that in itself is not always an easy thing to do. AJIPA is being monitored by a unit in the Office of the Attorney General. I believe it was set up by my colleague on the other side. Those are the public servants who bring us here this afternoon. Now, people of good faith can differ on the results of their work. We on this side happen to think that the legislation that is before us, and for the reasons, all of the reasons put by Senator Vieira, of all people, of all of those reasons, and I only say of all people because we often find ourselves in not armed but bitter struggle. But for all of those reasons, the fact that the legislation allows for speed, it invariably balances important rights, constitutional rights, and without foreshadowing what I will see in the legislative agenda that I was asked about this afternoon. The government intends to move legislation to allow citizens to have a constitutional right to a speedy trial. Now, the fact is that a JIPA fits in with that sort of philosophy, and that speed in criminal matters is not a bad thing. Just can't. Now, that is not to say that in achieving that result, we will railroad ourselves past some of the very valid concerns raised by my colleagues, mainly on the independent bench and by Senator Chote. But what I want to say, and I would not be long, is that I checked, and at least in Trinidad, I know that between 1917 and 2023, we have had JPs doing exactly what we seek to do this afternoon. So for the past maybe 18 months, we've changed the law. We know for a fact that the High Court has said that one of those changes that we made was wrong. It was unconstitutional and it was bad. They did that in 2023. Now, I'm not casting aspersions on anybody. I'm just saying that perhaps they had good intentions. But the fact is that the legislation was found to be unconstitutional and void. Now, we are here this afternoon to remedy that wrong and to listen to that unit which monitors this legislation. And they have said to us, listen, the stakeholders say that the system as far as it operates with respect to search warrants is in need of reform. Go back to the justices of the peace. We've tried this, it has not worked. Go back to the justices of the peace. Is a dispensation which is built on justices of the peace perfect? No, it isn't. It cannot be. But do you know what, Mr. President? The old system was not working. And when I said to my friends, show me where in the 2023 amendment, one place, show me where in the 2023 amendment, you all addressed your minds to the facts that, well, this is something that we are taking away from justices of the peace. And I challenged them. I said, listen, if you find it, because I didn't find it, I studied it, I think I can read. I did the best that I could do, but I asked them to help me. You know what was the response? There's nothing there, but that doesn't mean to say that we didn't think about it. Well, Mr. President, there was nothing there because they did not think about this. The fact is, it has not worked. The stakeholders have said it has not worked. We are here this afternoon. My friend the leader of government business has said that we take the point that we should not be giving JPs a jurisdiction greater than they have had between 1917 and 2023. And in the amendment which I have circulated, we have taken that on board. Another valuable point that was made by Senator Chote and repeated by practically everyone, and the system is not perfect. You have some corrupt JPs. I mean, they aren't the only ones in the society who are corrupt, by the way. But you do have some corrupt JPs, and that has to be dealt with. And I want to give the Senate an undertaking this time, with all the consequences which flow from that. I will do a reference to the Law Reform Commission, which is in the Office of the Attorney General, to tell us how we can look at legislative reform to treat with better standards of behavior on the part of justices of the peace. Because the fact is that there is legislation. I took Senator Chote at a word. When I looked, I saw that in the Bahamas, there was legislation which was not enacted just yet. 2025 legislation, which has not been enacted, to treat with justices of the peace. We want to look at it. We are people of good faith, good conscience. So that I will ask the Law Reform Commission to do work on this area. They'll get an Attorney General's reference, and I will undertake to bring to the Senate something that shows up, because it can only redound to the benefit of the justice system. Something that shows up the ethical, legal responsibilities of justices of the peace as soon as practicable. The legislative agenda for this year is all but set, but I would endeavor to do that within this year. Not this calendar year, but this year. Mr. President, we have in good, I don't want to speak to my colleague, Senator Janelle John Beats.
Yeah, don't worry.
I think that's a good place to stop for this afternoon.
Correct.
With those few words, Mr. President,
Thank you.
Honorable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
The Honorable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Administration of Justice Indictable Proceedings Amendment Bill 2025 be committed to a committee of the whole forthwith to be considered clause by clause.
Honorable Senators, the question is that the Administration of Justice Indictable Proceedings Amendment Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay. Honorable Senator, before we proceed, let me make sure everyone is on the same page, reading from the same script. First of all, I would like to inquire whether all members have in their possession the revised amendments of the Honorable Attorney General in their possession. That's the first housekeeping matter I would like to address. Secondly, we have in our possession, I ask other members here to advise whether you have in your possession amendment circulated by Senator Dr. Desirée Murray. You don't have it? It is in your email. Yeah, right. And the last set of amendments we have are submitted by Senator Faris Al-Rawi. I'd like to inform members would have in their possession and would have received these amendments.
Mr. Chairman, can I just ask for clarification? Yes. Thank you, Mr. Chairman. For clarification of the rationale for circulating one of the sets of amendments on paper, hard copy, and then others via email, just to clarify that, please.
Well, I understand that the government requested that their document, that is the revised amendments, be circulated to all members in hard copy.
Specifically.
So if other members in future would like
We'll
their
take that
hard copies circulated, they will make a request. All right. So we will now go to the clauses. There is not a very long bill, so we'll deal with the clauses one by one or clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 stands part of the bill.
Mr. Chairman.
Yeah, AG.
There's an amendment.
Right. All right, AG, you care to just elaborate?
Sure. The clause is a proclamation clause. Members will be aware that this is the type of clause you put into legislation when you think that you have something to do, so that you don't wish to proclaim, you don't wish the law to come into force immediately. And that thing that we believe needs to be done is 1, training, and 2, we wish to have a look at whether we need to go further with respect to legislating in terms of the duties and responsibilities on the JPs.
Okay. Anyone has any objection?
Mr. Chairman, thank you.
Yes.
Just seeking some further insight from the government. It wasn't provided during the debate, the concept of training. Is there a particular course or term of training that is being conceptualized? Is this something that arose today, or is there a program that is available to be elaborated, which will give us some sense of the time frame involved?
Okay. In the House of Representatives, my colleague, I think the Minister of Legal Affairs, he accepted that training of JPs was something that should happen. That, I think, is something that, well, any right-thinking person would believe should happen. Now, the proclamation clause does not prevent us from proclaiming the parts of the bill that are unobjectionable. So the bit on bail, I propose to move on that immediately, but I will tell the Senate this afternoon that the search warrants, that is something that I'm going to hold my hand on until we have examined that question, dealt with that.
So is it, Mr. Chairman, just a little further, thank you very much for that illumination, Attorney General. Is it that there will be some mechanism by which the government will revert to the Senate, or are we to rely on the discretion of the government?
That is not normal. I mean, if you could tell me what parliamentary procedure would allow us to have some sort of reversion to you, I'm open to that, to listening to you. The proclamation clause is, in my view, sufficient. It's not put into any of the amendments or the proposed amendments which are before me. It's a concession that I have made.
Again, I thank and acknowledge the Attorney General for that indication. It simply is a reflection of a paucity of detail. So there's a notion of training to be conducted, we assume, by the Minister or Ministry of Legal Affairs.
That's the ministry that has oversight of justices of the peace. I mean, as a practical matter, I have had some, I'm not sure whether Senator Al-Rawi has done this before, but I did have line responsibility for justices of the peace. And we did run extensive training courses when I had that responsibility, when we sat on the same side. I will look at encouraging my colleague to do some training. This is a serious responsibility that we are putting on justices of the peace, and we accept that. So we would want justices of the peace, we are Trinidadians, we would want justices of the peace to be properly trained. The government's position was articulated by the minister with line responsibility in the other place, and I'm happy to abide by that.
Thank you very much, Mr.
All right.
Mr. Chairman, if I may.
Yes.
Just a question to the Honorable Attorney General. Would that training be followed by some sort of certification?
That's what normally happens. It is training over a period of time. I can't say whether, with me it was a week. And at the end of the period, I remember giving out a certificate.
Follow up, may I?
Sure.
That certificate is automatic, or do they have to prove? Because in my experience as an educator, teaching does not equal learning.
So it is new, it is not at this time provided for in the legislation. It is something that I worked my way through when I was Attorney General because I felt that bailiffs as well. We would train bailiffs. There was a bailiffs committee which had a curriculum and so on. And these are persons who, there's a certain amount that, I didn't say it, I didn't allow myself to deal with Senator John Bates. But there's a certain amount of elitism that underpins the idea that ordinary people who we count on to play a critical role in the criminal justice system as jurors and to just exercise their common sense and to be persons of integrity. That is what jurors are supposed to be. Common sense, persons of integrity. You train them, you expect them to come to the training, and you expect them to, I'm going to ignore my friend. You expect them to come to the training and you expect them to apply what they have learned. I agree that the system as it exists is in need of reform. And I have indicated to the Senate that I will ask the Law Reform Commission to look at those models where you can perhaps make training mandatory, you can implement an exam system and so on and so on, licensing. Those are questions I believe for another day. Those things do not exist now, either with respect to bailiffs or justices of the peace. But I think it would be a positive development.
So just for my clarification, sorry.
Yes.
So just for my clarification, the proclamation would take all of that into consideration, including possibly certification by examination or, well, all other possibilities.
I don't want to get into that level of detail.
Right.
But what I'm saying is that, certainly with respect to the bail portion of the amendment, you have a decision of the High Court that we all, I don't think I've heard one person speak out against it this afternoon. So the legislation can go forward with that. That bit can be assented to by the President right away. But insofar as the search warrants are concerned, I'm going to hold my hand until my colleague has done what is necessary to train his GPs.
Okay.
In the existing dispensation.
Yeah, colleagues, senators, the question is that clause 1 as amended. The question is that clause 1 be amended as circulated by the Attorney General. All in favor say aye. Aye. Any against? I think the ayes have it. Clause 1. The question is that clause 1 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. Clause 1 as amended now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stands part of the bill. Those in favor say aye. Aye. Those against say no. Yeah. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. I know we have amendments as revised by the AG, and we also have amendments by Senator Al-Rawi and Senator Murray. May I respectfully suggest, with the reviewed or revised amendments coming from the AG, may I seek your leave to allow the AG to explain his revised amendment before taking the amendments from both colleagues. AG?
Mr. President, may I? Mr. President, may I?
Yes. Yeah, Attorney General.
Okay, so by deleting the original E, small e, replacing it with new subsection 1E, the revised wording, we think, defines better the scope of jurisdiction for magistrates, magistracy, registrars, clerks of court, and justices of the peace. It clarifies that these officers do not have jurisdiction over the matters referred to in subsection 1 or those assigned to a master under the Act. It ensures consistent interpretation and application of the law, thereby improving legal clarity and administrative efficiency. It's subject to 1B, which gives powers to them for issuing warrants and for JPs to grant bail. That's it. Do you want me to deal with 1B as well?
Yeah, well, I think we do the whole of clause 3.
Okay.
And you have a lot of...
So that provides precision and clarity in respect of the extent of concurrent jurisdiction exercisable by magistrates, magistracy registrars, clerks of the court, and justices of the peace, ensures that there is no ambiguity or confusion as to the limits of their authority under a JIPA. The new provision reinforces that these officers can issue search warrants aligning their authority with that of masters, thereby streamlining procedures and clarifying their roles. It extends the jurisdiction of JPs to include granting bail, particularly emphasizing the circumstances under which JPs can exercise that authority when an accused is not required to show sufficient cause or exceptional circumstances under sections of the Bail Act, which I've spoken to before. The amendment is intended to give legislative effect to the ruling in the Joel Alexander case. And I did make a concession. That is in 1C.
Mm-hmm.
It now reads that justice of the peace shall not issue a search warrant in respect of more than one set of premises at a time or exercise jurisdiction under section 5(1) large b. And that, of course, speaks to the point that Senator Chote made about the justices of the peace having an enlarged jurisdiction beyond that which they had, let us say, at common law between 1917 and 2023.
Any further elaboration?
That's it.
You're fine with me? Attorney General? All right. We have now heard the explanation for a new amended clause 3 as circulated by the Honorable Attorney General. I'd now like to ask Senator Al-Rawi and after Senator Murray to elaborate on your submission, or whether, before the AG, or whether, given the explanation given by the Attorney General, is sufficient for both amendments from Senator Al-Rawi and Senator Murray to be withdrawn. But that is up to you both. But I think the Attorney General would like to say something before you speak.
Just one second, Mr.
Okay.
Chair. There is one further clause, D. There's a new 10 sub 3. I'm not sure if colleagues are seeing it. Where the registrar grants an accused bail or remands him in custody, he shall cause the accused to appear or be brought before a master and shall transmit the record of the proceedings and all relevant evidence to the master. Or B, a justice of the peace grants an accused bail, he shall cause the accused to appear or be brought before a master. That's the policy decision to extend JP's jurisdiction to grant bail in limited circumstances. JPs will have authority to remand the accused in custody as registrars are empowered to do so. That's it.
Okay. Attorney, Senator Faris Al-Rawi.
Thank you. I thank the Attorney General for the amendment circulated. Could I please, before, I'm not proposing to deal with my submissions just yet, may I seek to ask the Honourable Attorney General to provide some clarification in relation to his amendments. So I'm going to state what I understand the amendment to be. I understand the amendment circulated in particular to clause 3. Firstly, if we look at the list of amendments circulated at the first page, we're saying, subject to subsection 1B, that the magistrate, magistracy, registrar, and clerk of the court, or a JP shall not have or exercise jurisdiction in any matter referred to in subsection 1. Subsection 1 is very important because it sets out the matters in section 10 which will fall outside of our positions. And if you'd permit me just to put it on the record, section 10 of AJIPA, which is the section that we're talking about, is search warrants, complaints on oath pursuant to section 6, summons or arrest, bail in accordance with Bail Act, fixed amount, take recognizances, and remand the accused into custody. That's very clear. It also says that it will not allow for concurrent jurisdiction for which a master is given jurisdiction. So the first thing that arises, if the Attorney General could assist me here, is this expressly going to allow that only a master will issue warrants under section 5A, that is big A of AJIPA. Those are the stored data and communication positions. That's the first question. Yes.
Only.
Correct. In other words, then there's no concurrent jurisdiction with respect to section 5, capital A of AJIPA, which is stored data and communications. That would take care of a number of concerns.
Did we allow that? We left that in, right? So, only the master. Did I say that? So, when I read out the explanation a while ago, I did see that you were taking out the jurisdiction of the, just a second, deleting the original paragraph A, replacing it with a new sub 1 large A, The revised wording explicitly defines the scope of jurisdiction for magistrates, magistracy registrars, clerk of the court, and justices of the peace. It clarifies that these officers do not have jurisdiction over matters referred to in subsection 1 or those assigned to a master under the Act.
Yep.
Now, 1B, which gives powers to them for issuing warrants and GPs, that is different.
Yes, so the reason why I asked is because 1B on the next page is subject to 1C. And 1C says only, so 1B says this class, magistrate, magistracy registrar, clerk of the court, JP, shall have, subject to 1C and 2, and exercise concurrent jurisdictions to masters to issue search warrants. I'm holding on to that word search warrant because there are many search warrants in a JIPA. There is a search warrant in section 5, capital A, and that is specifically for stored data, etc., under the Interception of Communications Act provisions. So I just wanted, out of an abundance of caution, to ensure that the caveat to 1A, which is 1B and 1C, which I'll come to in a second, does not trigger the risk that section 5, capital A warrants can be allowed, because you have search warrants under 5.1 and you have search warrants under 5A. And therefore I wanted to be sure about that. Because 1B creates that exception, and then 1C I'll come to.
Okay, so if we take the intercepts out of it under IOCA, you're dealing with stored data. And our thinking is that whether data is stored on an electronic device or not, it is amenable to the ordinary jurisdiction of the justices of the peace, correct? So that there should be no hindrance to a JP issuing a warrant to get at stored data. This is not an intercept under IOCA.
Thank you, Honorable Attorney General. Save that IOCA itself only allows warrants for those categories of things to happen by a judge.
No, it says me. The section says a judge may issue.
Yes, well, that preserves the discretion of the judge to issue it or not issue it. But the point is that the species of interception is live intersections pursuant to Section 8 and Section 11 of IOCA, Interception of Communications Act. That's one category. But stored communications is another category of warrantable material under Interception of Communications Act. And under that law, you can only access it via a judge, not a subsidiary, forgive me, not a master, not a magistrate, not a registrar. None of them are permitted that privilege.
Say again? Well, I mean, my view is that there should be no let or hindrance to JP issuing a warrant for material, even if that material is stored on a cell phone. It's not an intercept which is covered by IOCA.
Thank you, Honorable Attorney General. When the IOCA, just a further question. As I understand IOCA, having amended it several times, IOCA is a live intercept which is Section 8 and Section 11 of IOCA. And it is also a delayed intercept for things that are stored, traffic data, communications data, and stored
that
data.
wouldn't be an intercept. It would be storing of intercepted material.
Storage of material which was used in the course of things which you could intercept. So it is WhatsApps, it's text messages, it's
Correct.
all of these things that are stored
So
on
it's-
electronic devices.
It's data.
Sure. I just want, for my purposes, to understand the positions. I'm not going to complain about the policy which the government has, but it's to inform me. I have a further question, if you'd entertain me.
Sure.
So we're saying in respect of, so we go from 1B, and 1B has a caveat that says 1B is subject to 1C and subsection 2. Subsection 2 is fine because that's, you can have a warrant issued on a Sunday, etc., etc. So subsection 2 doesn't concern me. Question is in relation to 1C. So 1C says, and here is the generous build-out of the quote-unquote concession, the common law positions of the justices of the peace. So 1C says, a justice of the peace shall not issue a search warrant in respect of more than one set of premises. Now, or exercise jurisdiction under 5(1)(b). In 1CA, 1CA is tied, the issuance of search warrants. The reason why I asked about the provisions earlier, that is stored communications 5A, was to make sure that we're talking about specific warrants. So you've answered that. When we're talking about 1CA, issue a search warrant in respect of more than one set of premises, we jump to understand it in context, we jump to Section 5 of AJIPA. And Section 5 of AJIPA is the master being satisfied, he can issue a warrant, anything indictable offense, anything reasonable grounds for suspecting will afford evidence, anything which is reasonable grounds. That comes from the preliminary inquiries legislation, Section 5 by itself. That's fine. But when we get to 1A, notice the caveat is 1B, it's not 1A, 5(1)(a) of the AJIPA. A search warrant issued under subsection 1 may authorize the search of one or more sets of premises. You've curtailed that with 1C by saying only one set of premises. But what is not treated with is 5(1), Roman 1. 5 Roman 1 says, so let's assume that we apply one set of premises. That's an A. So our JP in this 1C can only issue in accordance with section 5, 1 capital A, small a warrant for one set of premises. But B says, any premises occupied or controlled by a person specified in the warrant, if the master is satisfied, and here are the qualifications, because of the particulars of the indictable offense referred to in subsection 1, there are reasonable grounds for suspecting that it is necessary to search premises occupied or controlled by the person in question which are not specified in the application for search warrant in order. In other words then, one set of premises which are unknown, if I read it out in plain English. Roman 2 says, one set of premises, now I'm borrowing 1C's curtailment, it is not reasonably practicable to specify in the application for the search warrant all the premises which the person in question occupies or controls. That also satisfies one unknown set of premises. So you get a warrant from a JP to search John Brown, whose premises are unknown. It satisfies 1C. Now, this 5(1)(a) was the widening of AJIPA well beyond the search warrant facilities in the preliminary inquiries old law. If you look to section 5 of the old law, it has none of this breadth, because the breadth is more than just one set of premises. It now provides for a search warrant for unknown premises, uncertified premises. You just don't know. You get a search warrant to search the one premise of John Brown. So whilst the amendment at 1CA treats with one of the mischiefs, the common law, if you want to look at it from a codification of statute point of view, the Preliminary Inquiries Act, Section 5, where warrants are given, is much narrower than Section 5(1)(a), of a jipper. So how do we curtail those mischiefs? Because our concern was much broader than just one set of premises.
Sure. Senator
Sure.
Chote.
Yes.
I'm not really following what we are discussing here, because it seems to me, with all due respect, that by saying that the Justice of the Peace shall not issue a search warrant in respect of more than one set of premises at a time means that the Justice of the Peace in any set of circumstances can only issue a search warrant for one set of premises. I'm not sure if I'm not following.
I'm struggling to see that there's another meaning, out of respect for Senator Al-Rawi.
But perhaps I can explain.
Yes.
That is my interpretation. I'm being very patient and I'm trying to understand Senator Al-Rawi's point.
Appreciate it. Perhaps I can lend some elucidation. I'm reading directly out of Section 5 of a JIPA.
So if you could see, the difficulty this afternoon was that the Justice of the Peace, who never had a jurisdiction to issue a warrant in respect of more than one set of premises. We've cured that by 1C small e. Mm-hmm. What else do you say we have not got?
Sure. So it targets the express permission to issue unknown premises, even if it's one. The one premise of John Brown, which I don't know, that is captured by Section 5, 1 capital A, Roman 1 of a JIPA. That's specifically what it captures. But you'd have to read it to see it. I don't know if you have it before you, AG.
I know the section, I don't have it before me, but I think that the point is that the JP has a power to issue a warrant for one set of premises. That's it.
May I add the words? The JP's power prior to this 2023 amendment was that you could issue a warrant for one set of described premises. Number 1, Abercrombie Street, Port of Spain.
A set of premises obviously has to be described.
No.
It can't be.
So that's exactly the point. In a JIPA, 1 capital A says that you can get a warrant for premises that you're not aware, you don't know the address for. That's what 1A says. It's in black and white.
Okay, but if that is so, then the search warrant obviously will be bad. I mean,
sure.
As far as I'm aware.
But sorry to interrupt you.
You get us. I mean, this is my understanding of the practice. I've practiced less criminal law than Senator Chote, but I suspect a little more than you are.
Sure.
Obviously, when you go to get a search warrant, you have to say where you're going to search. At common law, right? You have to give a description. I mean, it's a case, that central broadcasting case that I...
So AG, I agree with you, but I'm borrowing now from the construction that Justice Gubin engaged in saying what the law did not say. So the law says...
She now is, that's on bail.
No, but I'm just borrowing the methodology. So I accept that that's bail. So in construing the law, we're saying here one set of premises. But we as a parliament, in just leaving 1C as it is, we're not disapplying the power of the Justice of the Peace to go on unspecified premises under 1A. It's curable by saying that the JP will not have the power under 1A. It's curable that way. It confines the JP to one set of premises which are known.
Okay. I disagree. I think that this section is clear as drafted.
Thank you for the elucidation. Mr. President, I don't propose to engage in any debate. The AG has answered what I wanted, which was the policy of the government, because it would inform our support or non-support. So for the record, thanking the Attorney General This is not a place to debate the policy. My reservation has been stated. There is a danger in 5(1) capital A, Roman 1 of a JIPA. Thank you.
Okay. So, all right. Senator Murray.
Thank you, Mr. Chairman. So I've been trying to follow the discussion, and am I correct in that everybody would be comfortable with saying one set of known premises? Is that what I got from that, or did I not follow correctly? Is it the known versus unknown?
Before you go on, let me come back to Senator Al-Rawi. You have specific amendments to clause 3.
Yes, sir.
Are you withdrawing?
No, sir. Because we're still...
Well, can I put your question? Because, you see, if you're not withdrawing, we have to settle before we go on to Senator Murray.
May I ask for your guidance on something?
If it is that you are not withdrawing,
yeah,
and the AG has clarified the position of his side, what I'm saying is that we'll have to put your question.
Sorry. So, Mr. Chairman, because we've tabled up the first at T is the AG's amendments, and we've not voted on that yet. The next sequential position will be the other amendments proposed. So I took this exercise, which I'm very grateful for, and for the responses of the government, to be the interrogation of the amendments proposed by the Honourable Attorney General. So I didn't see that procedurally we were yet in a position to table or consider my amendments. I understand that we're still discussing the Honourable Attorney General's amendments.
Well, we cannot continue doing that for the whole evening. So what I'm saying is that the Attorney General has clarified his position. You have sought further clarification. I think that we have exhausted that. So what I'm saying is that can you now put your amendments forward and clarify? So if the AG has to respond, he would be in a position to respond to your amendment.
And for your guidance, Mr. President, Honourable Chairman, is it that we will then, after I put my amendments, then vote for the AG's amendments, and then you see, my problem with the approach suggested is that we have not completed the Honourable Attorney General's amendments procedurally.
The AG has clarified his amendment. We will put his amendment last. The question of his amendment will come last. Your amendments are before us. I am seeking...
Sure, I happily. Thank you for the clarification.
Clarify so we can
You've clarified the procedure. It's your direction. I'm happy to oblige. Thank you, Mr. President. My amendments as proposed are really quite simple. They propose the elimination of justices of the peace from the category of persons that can issue search warrants. They don't touch at all the proposed amendments which we'll come to later in relation to bail, which we agree with. My amendments are tabled on the fact that the opposition's position, at least my own position, in relation to search warrants is specifically that if we were to propose the bill as proposed to be amended by the government, we would run into hot water with the search warrants that are permitted by justices of the peace under section 5(1) capital A, which is more than just premises which are described, which is in 5(1), but in 5(1)A, it allows for unspecified premises, being one alone if we take the AG's amendment as it is. And for those reasons, I propose the amendment as circulated.
So I'll put the question. The question is that all right, I'm being advised now that Senator Al-Rawi has put forward his position on clause 3, which is his amendments. Are there any other views that anyone would like to express as it relates to Senator Al-Rawi's amendments? Before I put the question. Sure. Yes.
To say that it seems to me that the proposed amendment by the Honourable Attorney General takes away or should take away the concern that Senator Al-Rawi has with respect to the other possibility for use of the subsection to which he refers. So otherwise, you would have a section, and I know when lawyers start to talk this way, people just shut off, but forgive me, it is the only way that I can explain it. Otherwise, we would be reading it in such a way as to read it to say that this section is inconsistent with itself, and that is not permitted according to the laws relating to statutory interpretation. That is just my very humble and respectful view.
Thank you very much. Thank you very much, Senator Chote. So the question is...
Mr. Chairman, as you're putting it to the vote, and
Yes,
insofar as the mover
vote.
usually has a reply to the submission, insofar as the mover usually has a reply to submissions made, may I just simply, in response to Senator Chote, say, the point is that it will have to be tested in court, and we have the option to expressly disapply Section 5(1)(a). So for those reasons, I understand where she's coming from, but I bet $1 at least that it will be tested, and I'm seeking to avoid that. Thank you, Mr. Chairman.
Okay. The question is that clause 3 be amended as circulated by Senator Faris Al-Rawi. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. Dr. Murray, can you proceed?
Thank you, Mr. Chairman. My proposed amendment has to do, as I stated in my contribution, with training and certification. So, with regards to clause 3A, and I think also to 3(1) capital B of the Attorney General's most recent circulation. Anyway, it's the same. I think after Justice of the Peace, I am proposing that we add the words, who has undergone approved standardized training and certification for the issuance of warrants. That's 3A. And then for 3B, I know I did not cover it in my contribution, but I would like to apply the same logic to bail and say that after the words Justice of the Peace, who has undergone approved training and certification for the issuance of warrants and granting of bail. I apologize, but I didn't have much time to try and understand the Bail Act.
You're requesting a further amendment?
I'm requesting an amendment to my amendment by adding the words.
Can you repeat the words, please, so we can have notice?
So in my amendment, clause 3, capital B, I'm proposing that after the words Justice of the Peace be added, who has undergone approved standardized training and certification for the issuance of warrants.
You're going fast, too fast.
Oh, I'm so sorry.
All right, go ahead. Okay.
Yeah, and then the amendment to that amendment would be, and granting of bail.
Okay. Attorney General, would you like to respond, obviously, to these amendments?
Mr. Chairman, we have put in a proclamation clause, and I have given an undertaking, which I think is as far as I can go. I cannot support the amendment as it is drafted, but I have given an undertaking to this matter falls within the Ministry of Legal Affairs now, and I know that my colleague in the other place has said that he intends to ensure that justices of the peace are trained. Now, when he said that, it would have been in respect of search warrants, because that was the bill in its shape downstairs before the decision of Justice Gobin, which came 5 days after. But I expect that that training would extend to bail, and that is as far as I can go.
So, Senator Murray, would you like to put your question, or are you withdrawing your?
No, I'd like to put the question, please.
You'd like to propose? You'd like to put the question? Okay, the question is that clause 3 as be amended as circulated by Senator Desirée Murray. Those in favor say aye.
Aye.
Those against say no.
No. Division.
Mr. Allahar?
No.
Mr. Jeremie SC?
No.
Mr. Roberts?
No.
Dr. Swarat Singh?
No.
Mr. Batiste?
No.
Mr. Alexander?
No.
Mr. Ratiram?
No.
Professor Prasad?
No.
Dr. Chaitan Maraj?
No.
Mr. Big?
No.
Ms. Charles?
No.
Mr. Zakur?
No.
Mr. Naked?
No.
Mr. Jack?
No.
Dr. Megu?
No.
Dr. Brown?
Yes.
Mr. Al-Rawi?
Yes.
Mrs. Roberts-Radgman?
Yes.
Mr. Dan Paul?
Yes.
Mr. Cummings?
Yes.
Mrs. John Bates?
Yes.
Mr. Vieira SC?
No.
Ms. Chote SC?
No.
Ms. Jones Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
No.
Mr. McNish?
Yes.
Mr. Heath SC?
No.
Order, please, order. We want to hear the voices in silence. Continue, please.
Mr. Heath SC? Dr. McPhee?
No.
Mr. Chairman, the result of the division is as follows. 8 senators voted for the amendment, 22 senators voted against the amendment, and there were no abstentions.
Honorable Senators, the results revealed that 8 members voted for the amendments, 22 members voted against the amendment. There were no abstentions. The motion, the amendment to clause 3 as circulated has not been approved.
You could put the question in the ages. What do we want to close for?
Honorable Senators, the question is that Clause 3 be amended as circulated by the Honorable Attorney General. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The question is that Clause 3, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. Clause, I think the ayes have it. Clause 3, as amended, now stands part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill. Senator Al-Rawi?
Yes, Mr. Yes, thank you, Mr. Chairman. Having a telephone tag with the microphone. Mr. Chairman, quite simply, the amendments that I have proposed to Clause 4 are driven by my concern in relation to the matters I suggested for Clause 3, which is that there is an express danger in Section 5(1)(a), warrants, which allow unspecified premises, which could be just one. And in those circumstances, in default of disapplying Section 5(1)(a), I've proposed this amendment for consideration. Thank you.
Attorney General, would you like to respond?
Mr. Chairman, the response is the same as it was before.
Any further interventions? Let me put a question. The question is that Clause 4 be amended as circulated by Senator Faris Al-Rawi. Those in favor say aye. Aye. Those against say no. No. I think that the noes have it. I think the noes have it. Right? Clause 4. Yes. Yes, yes. As such, the amendment is not approved. Okay, we proceed. Senator Dr. Murray.
Thank you, Mr. Chairman. My rationale is the same as before, so given how the previous vote went, I withdraw my proposed amendment.
Thank you, Senator Desirée. I now have to put a question to Clause 4. The question is that Clause 4 now stand part of the bill. Those in favor say aye. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
New Clause 5.
The question is that new Clause 5 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New Clause 5 will now be read a second time.
New Clause 5.
Yes. The question is that new Clause 5 be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
That's it? Thank you.
Yeah.
Okay.
Let me just re-put the question. The question is that new clause 5 be added to the bill. Those in favor say aye. Aye. Those? All right. I'm advised. I'm rushing. I don't know why. But we have to give members the opportunity to make their input to clause 5. So clause 5 is now open for members' input. AG, could you explain clause 5? Clause 5.
So the amendment is intended to give legislative effect to the ruling in the case that we've been speaking about for the entire afternoon, Joel Alexander. I believe even my colleagues on the other side will. Let me not say what I believe they'll do. Say again?
For the record, we do support it, AG. We support it fully.
Mr. Chairman.
Yes.
Yes. That is the explanation.
Okay. Any clarification, any intervention? The question is, therefore, that new clause 5 be added to the bill.
What is your...
Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 5 is added to the bill.
The long title.
The Attorney General will want to just address that matter.
No. Did I amend the long title?
Just provide an explanation for the reason for the long title. That's all. The long title. Changing.
Yeah.
For the record, that is.
Yeah. It is to clarify and expand the scope of the bill by explicitly stating that in addition to amending the Administration of Justice Indictable Proceedings Act, it also includes making consequential amendments to the Bail Act and addresses other related matters. So the addition ensures that stakeholders are aware that the bill's provisions will have implications beyond the original act, particularly concerning bail procedures, which we have put in now.
Honorable Senators, anyone would like to seek any further clarification? Honorable Senators, in accordance with Standing Order 68, subsection 12, the long title of the bill is amended as circulated by the Attorney General. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Over to the Attorney General. The Honorable Attorney General.
Mr. President, I wish to report that the Administration of Justice Indictable Proceedings Amendment Bill 2025 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that a bill entitled an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, and to make consequential amendments to the Bail Act, Chapter 460, and for other related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
That was the question on the report.
Would you, Johnson? Honorable Senators, the question is that the Senate agree with the committee's report on the Administration of Justice Indictable Proceedings Amendment Bill 2025. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, and to make consequential amendments to the Bail Act, Chapter 460, and for other related matters, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, and to make consequential amendments to the Bail Act, Chapter 460, and for other related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it.
Mr. Allahar.
Yes.
Mr. Jeremie SC.
Yes.
Mr. Roberts.
Yes.
Dr. Swarat Singh.
Yes.
Mr. Batiste.
Yes.
Mr. Alexander.
Yes.
Mr. Ratiram.
Yes.
Professor Prasad.
Yes.
Dr. Chaitan Maraj.
Yes.
Mr. Beeg.
Absolutely yes.
Ms. Charles. Mr. Zakur.
Yes.
Mr. Nakid.
Yes.
Mr. Jack.
Yes.
Dr. Megu.
Yes.
Dr. Brown.
No.
Mr. Al-Rawi SC.
No.
Mrs. Roberts-Radgman.
No.
Mr. Dan Paul.
No.
Mr. Cummings.
No.
Mrs. John Bates.
No.
Mr. Vieira SC.
Yes.
Ms. Chote SC.
Yes.
Ms. Jones Simmons,
Yes.
Mr. Lewis,
Yes.
Dr. Murray,
Yes.
Mrs. Lalit Etienne,
Yes.
Mr. McNish,
Oh, yes.
Mr. Heath SC,
Yes.
Dr. McPhee,
Yes.
Mr. President, the result of the division is as follows. 24 senators voted for, 6 senators voted against, and there were no abstentions.
Honorable Senators, as a result of the division, 24 members voted in favor of the bill, 6 members voted against the bill. There were no abstentions. The bill has been approved. The Honorable Leader of Government Business.
Mr. President.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2012, Act number 20 of 2012, and to make consequential amendments to the Bail Act, Chapter 460, and for other related matters.
The Honorable Leader of Government Business.
Mr. President, now that the bill has been literally read a third time, I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Etienne, please.
Mr. President, honorable senators, the viewing public, and the media, I stand here this afternoon to highlight an important, very crucial topic, which is street dwellers and the health and security issues. Mr. President, could you give me, when it's 5 minutes before my time is up, could you give me a heads up, please? All right. Now, this has been a global problem. And for our country and for our capital, we, the socially displaced, it has reached, I would say, epidemic stages in our wonderful city. And I don't know if you all remember and could identify to this song by Petula Clark, 1964, Downtown. When you're alone and life is making you lonely, where do you go? When your worries seem to surround you, where do you go? The neon signs downtown, the pretty neon signs. Well, it's not that case for our capital. I am a citizen of Trinidad and Tobago, and anywhere I go, I am proud to be a citizen. When I studied abroad, I adore my accent, and I am proud. And I'm sad to say that even though I cannot see, our capital needs desperate help. And what happened is that our neon signs are replaced by socially displaced individuals. And we all could say yes. And even though socially displaced individuals have rights, you have the Socially Displaced Legislation 2000, and the Human Rights Committee and Equality in the 12th Parliament did extensive research and they have came up with an extensive report on solutions plaguing our city. And what happened is that we need to address it in a collaborative way. This issue have been brought up in the Senate years ago, and I'm bringing it to your attention again because, one, it's a health risk because of what is left behind with these socially displaced individuals, even though they have rights, and the security risk. And I could identify with it because I am an independent person, and I walk the streets of Port of Spain. And on a couple of occasions, I got attacked by socially displaced individuals, and people had to run to my rescue. Now, when a socially displaced individual damage you and damage you for life, you have no set of regrets. You have no compensation, nothing at all. And even though they have rights, we have rights too. Our solution is not, it's filthy, and let's head for the malls. No. Right now, the government is engaging a lot of international collaboration and business, strategic business partners, even with headquarters in Port of Spain, and look at the condition. And I am pleading to the government, if because I am a citizen of Trinidad, if we could prioritize, thank you, if we could prioritize this situation. We have rights, they have rights. Maybe you could look to, continuing the construction on the east side of Port of Spain because they have blanketed Port of Spain. They are no longer on the east side of Port of Spain. We're talking about tourism. And when cruise ships come to our shores, Carnival, all right, we want to advertise our wonderful city. What we are met with is an epidemic of socially displaced individuals. We are afraid to even sit on the promenade and even in the parks because it's filthy. It's a health risk, and it's also a security risk. People are scared, literally scared. So I would like to plead to government to somewhere make it a priority. Last sitting we had while coming up Abercrombie Street is a good thing I cannot see. Sometimes it's a benefit. You had a socially displaced person happily having a shower a few steps outside of the seat of Parliament. It's a serious situation, and to save our city, the mayor wants to buy new equipment and stuff, but we need to deal with the socially displaced. So I would like to conclude by saying I kindly ask in the government if they can make it a priority for the sake of everyone, for the sake of persons with disabilities, for the health concerns and security, if you could really pay attention to the socially displaced. Thank you.
Parliamentary Secretary, the Ministry of Social Development, the People, Family Services.
Mr. President, thank you for the opportunity to address this motion. Street dwelling is a complex social issue that touches public health, safety, urban cleanliness, as said, and most importantly, the dignity of our most vulnerable citizens. Our ministry's approach is compassionate, coordinated, and accountable, balancing urgent action with the responsible stewardship of public funds. To address it at the view of scale and realities, Mr. President, empirical data indicates variation over the recent years, not a blanketing. In Port of Spain, 211 street dwellers were identified in 2019. 336 were counted in March 2021, including Woodbrook and St. James, and 235 in 2023. These figures represent a dynamic population influenced by multiple pressures and ongoing interventions. The Social Displacement Unit of the Ministry of the People, Social Development and Family Services leads the national response, assessment care, rehabilitation, and reintegration of street dwellers. Between October 2024 and July 18, 2025, the SDU conducted 1,929 street engagements and investigations, made 260 shelter and care referrals, 51 rehabilitation referrals, and 199 referrals to other social programs, supported 72 deportees, and facilitated 17 transitions to independent living. In total, the activity count is 2,676. These are concrete outcomes from persistent, on-the-ground outreach. To address concerns of infrastructure and service expansion, Mr. President, following the decommissioning of the Center for the Socially Displaced at South Key, Port of Spain in 2022, construction of a new 5-story assessment center for the socially displaced at Old Foundry Road, South Key, commenced in 2024. As at June 30th, 2025, works are 49% complete, with completion scheduled for the fourth quarter of 2026. This center will provide assessment, temporary housing, and referral services, including mental health, rehabilitation, and social support, within a housing-first policy orientation. Looking at legal and operational pathways, Mr. President, under the proclamation of the Socially Displaced Persons Act, which was assented to on November 2nd, 2000, the state relies on existing laws, for example, the Summary of Offences Act, Mental Health Act, and Police Act, to enable compulsory assessment and care only where warranted, always exercising safeguards and judicial oversight. This ensures we protect the wider public while respecting individual rights. To address Senator Etienne's public health and community well-being concerns, Mr. President, unmanaged street dwelling increases risks of communicable disease transmission, environmental degradation, and incidents in public spaces, agreed, while exposing street dwellers, on the other hand, to violence, exploitation, and harsh conditions themselves. Our response will therefore combine engagement of public health departments within municipal corporations with medical and social assessments during outreach and coordinated placements into care. The constraints we are overcoming: we acknowledge gaps in specialized shelter capacity, particularly for women, persons with disabilities, and clients requiring mental health and substance abuse treatment and skills training. Repurposing of legacy facilities reduced training opportunities, and the not in my backyard sentiments complicates siting of services. These realities are precisely why the ministry is scaling infrastructure, strengthening partnerships, and advancing policy reforms. This is not a task for government alone. Our collaborative plan includes interministerial coordination, municipal partnerships, civil society and faith-based organizations, decentralized drop-in centers, mobile outreach, and linked data systems to track client journeys. The objective is seamless care from street engagement to treatment to independent living countrywide. Our commitments and immediate steps, Mr. President. In the immediate term, we will act. We will maintain weekly street engagement with rapid assessment and referral. We will prioritize those at risk most: women, older persons, persons with disabilities, and individuals with acute mental health needs. We will explore the expansion of transitional capacity while the Assessment Center for the Socially Displaced is completed, including any current facility which may be fit for purpose. Active engagement and collaboration with NGOs currently working with the socially displaced will be pursued and further leveraged to enable access to required support systems. Where risk is high, we will continue to use legal tools available, always rights compliant, to secure compulsory assessment and care, and we will intensify public education to reduce the stigma and build community support. I therefore ask this Honourable House to support full resourcing of the SDU staffing and specialised placements, to promote stronger collaboration between stakeholders, ministries, departments and agencies, to back data sharing across agencies for better case management, and to advance a legislative pathway to proclaim and modernise the Socially Displaced Persons Act with robust safeguards. In closing, Mr. President, the Ministry of the People, Social Development and Family Services is resolute. We will protect public health and safety while upholding compassion, dignity and human rights. Every citizen matters. We ask the House and our national community to stand with us as we move people from the streets to stability, recovery and reintegration. I thank you, Mr. President.
Honourable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.